avoid disturbance. Yeah, thank you. So a very pleasant afternoon to all the esteemed speakers from Mumbai, India, and Maharashtra National Law University, Mumbai. I, Sajid Sheikh, I welcome all of you to the virtual roundtable discussion on utility model protection under Indian scenario. This roundtable discussion has been conducted by DPIIT IPR Chair of MNLU Mumbai and Center for Research in Intellectual Property of Maharashtra National Law University, Mumbai. You must be aware MNLU Mumbai is a premier national law university in India, and it has been established by the government of Maharashtra. So 5 years ago, we had our inception, our university started, and under the able guidance of our Honorable Vice Chancellor, I am very proud to say that we are one of the much cherished universities by all the law aspirants in India and in some parts of the world also. Straightway, I'll now introduce firstly our Honorable Vice Chancellor, who will be delivering the welcome address. Professor Dilip Uke, he is, of course, a Vice Chancellor, and he is an erudite jurist in jurisprudence, constitutional law, human rights, and his work has been personally appreciated by Justice Krishna Iyer. And he is a leader with a vision, and he has made MNLU Mumbai, of course, much cherished university, much liked university by the students. And in these tough times in India, if you are hearing the news, while a lot of debates are happening to conduct the examination, not to conduct the examinations, under his leadership, Mumbai, we conducted the online classes, declared the results. Our first batch of students have recently passed out in June 2020. And recently he was awarded with Indian National Bar Association Best Law Teacher Award. And he has written a lot of books, research papers, and he is a very well-known expert. Over to you, sir. I request you to kindly deliver a welcome address and about the university to this very august audience today, sir. Over to you, sir.
Thank you, Mr. Sajid. All the respected speakers, our in charge registrar, Dr. Anil Variyat, and all my colleagues. Very, very good afternoon to all of you. I welcome all the esteemed speakers from top industry professionals, policymakers, and members of the academia to this virtual roundtable discussion on utility model protection under Indian scenario. As Mr. Sajid has pointed out that our university was established, Maharashtra National Law University was established 5 years before. We are now in the 6th year. The first batch has been just passed out. We offer BA LLB honors courses as well as regular LLM 1-year course and PhD in law. However, from this academic year, as we are aware, we know all we are facing the challenges in life due to this pandemic. However, this pandemic did not deter our spirit and our energy, because we have introduced 3 new master's courses from this academic year. One is must sought after and very novel master's degree in MA Executive in Mediation, a brainchild of Honorable Chief Justice of India, who is our Chancellor, and wherein now admissions are almost over. The classes will begin in the next month onward. Most of the faculty are from abroad, as well as some students also are from abroad. It is a 2 year course. And I'm really happy to share with you all that Maharashtra National Law University Mumbai is not only university in the country, but rather it is the only university in the whole Asia which offers this master's degree exclusively in mediation. Another course which we have introduced from this academic year is LLM in investment and security laws in association with SEBI, Security and Exchange Board, Government of India, and its institute NISM, which is really a novel course wherein the people, experts from industry will be the faculty, and admissions are over. 400 candidates had applied for that course, wherein only intake is 60. Admissions are over. Entrance test, then interviews, personal interviews, and then thereafter, after the screening, the admissions were over. So that course will also roll out in the first week of the next month, after a few days. Similarly, as we know that there are several people who graduated in law, like judges or advocates or any officers, bankers or IS officers. However, because of their business or service, they cannot go for the further higher education and to do their masters in law. For such professionals, we have also introduced from this academic year LLM professional, and rather admissions are already over. Classes are already going on of this course. With this brief introduction, we have rather along with this we have 10 centers like this IPR center, mediation, arbitration, maritime, so on and so forth. And due to these centers, through these centers, we conduct training programs, workshops, seminars, and all other activities like this roundtable discussions also. Dear friends, Department of Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India has established an IPR chair under the scheme for pedagogy and research in IPR for holistic and education and academia. The university also has established its own center, as Mr. Sajid has pointed out, for research in intellectual property with an aim to foster research, awareness, and capacity building in the field of IP. As you know, as you are aware, that the intellectual property is a subject of increasing global importance. Policymakers have long recognized the need for IP rights to protect the inventions and creative works of individuals and firms. In an age when knowledge capital, the product of the intellect, has become an increasingly important basis of social and economic progress, IP has acquired unprecedented importance, and issues relating to the generation, evaluation, protection, and exploitation of IP systems have become very crucial, very important. All too often, however, the ingenuity of innovators and creators in developing countries goes unrewarded, and as a result, their countries miss out on major potential advantages. That is where the intellectual property system can play a very major role, critical role. IP is a powerful tool for development, used strategically by governments, businesses, and the non-profit sector. IP can generate huge economic, social, and cultural benefits. Furthermore, India is a land of frugal inventions. However, if the rigid patentability criteria were to be applied to these innovations, none of them would be eligible for grant of patent under present Indian law. However, in a resource-constrained economy like ours, these minor technical inventions, which frugally use local resources in a sustainable manner, need to be encouraged by providing a legal framework for their protection and commercial exploitation. Such very needed and useful, low cost and relatively simple innovations, which create new mechanical devices or contribute to the optimal functioning of existing ones, may have commercial value only for a limited time period before they are replaced by other products or rendered redundant by change of technology. This is where I think that we need to explore the possibility of adopting utility model protection by having an open and in-depth deliberations on the pros and cons of utility model. I once again welcome all the esteemed speakers and all of you, and thank all the esteemed speakers for participating in this roundtable, and invite all of you to join hands with the Research Center for more meaningful collaborations. I wish my very best to you all for this roundtable. Thank you so much.
Thank you so much, Professor Uke, for introducing the university, and definitely under his leadership and with his a kind of a boost which he gives to all of us, and the kind of flexibility he gives in the academic sphere, we are able to conduct such programs in our university. Thank you so much. Next is, as you all know, Professor T.C. James. He is our chief guest today. Of course, he's a man of no introduction. He needs no introduction at all. He's a highly distinguished expert in the field of intellectual property. He is the president of NIPO, which is a renowned association of various IP stakeholders. He also serves as a visiting fellow in the Research and Information System for Developing Countries, and he's also visiting faculty of Indian Academy of International Law and various other academic institutions. Formerly, he worked as director of the IPR division at DIPP. He has made a lot of policy interventions at national and international levels, and he has also authored a lot of books and research papers on the various facets of intellectual property. Professor James, we are very really honored to have you today with us as our chief guest and as a keynote speaker. So I now request you to kindly deliver your address, sir. And thank you personally for joining us today, sir.
Thank you, Sajid. Professor Dilip Uke, Honorable Vice Chancellor of Maharashtra National Law University, Dr. Dhumane, DPIIT IPR Chair Professor, and my old colleague, friend, everything, eminent experts. First of all, my congratulations to the Honorable Vice Chancellor, Dr. Dhumane, and the Center for getting a galaxy of IPR experts in one forum. The experts list reads like a who is who of Indian IPR scenario. Congratulations also for selecting a topic that's of great relevance to the current context when the country is once again with the slogan of a self-reliant India, Atmanirbhar India. There was a time not long ago, economists and policymakers were talking ad nauseum about globalization and international trade. Now the discussions are more about Make in India. This necessitates a relook at our approaches to innovation and innovation protection, including on adapting technologies for domestic market. This roundtable is highly relevant in that context. Utility model protection is a subject close to my heart, as many of the assembled experts here already know. It has been a topic on and off the IP policy firmament of India frequently. This was one of the subjects on which a study was commissioned by government in 2007 as part of EU-India Trade and Investment Development Program. During the same year, Dr. K.S. Kardam, one of the experts present in this roundtable, then a controller of patents and designs, undertook a detailed study on utility model, a tool for economic and technological development, a case study of Japan, in Japan, under a long-term fellowship from WIPO. This report is available on the IP India website. Later, some internal discussions were held within the government on drafting a sui generis legislation for protection of utility model, but abandoned after some time. The issue was revived in 2012 when a discussion paper was prepared and published on its webpage by the then Department of Industrial Policy and Promotion. The industry organizations responded to this very positively. I remember FICCI in its response said that it had received an overwhelming response from micro and small enterprises and Indian innovators who had felt that the time was apt and there was a great need for a system which can accord protection to their innovations which are incremental in nature. Dr. Sheetal Chopra, who was in those days with FICCI, is present today and she can throw more light on those deliberations. Again in November 2013, I remember the then Union Minister for State for Commerce and Industry, Mr. E.M. Sudarshana Nachiyappan, addressing a conference on valuation and monetization of knowledge assets with the theme Translational Intellectual Property Strategies for Businesses, organized by the Confederation of Indian Industry, requested academicians and industry to work out a utility model protection system for the country to improve commercialization of innovations. Then the task force set up to draft a national IPR policy in its first draft issued for public discussion referred to utility model protection. However, the final national IPR policy 2016 document is silent on this issue. Some of those who objected that time in the responses to the task force were basing their arguments on a larger premise that the impact of IP protection on innovation itself was debatable. Some also felt that it would lead to dilution of the quality of patents granted in India. Though the national IPR policy does not make any specific statement on protection of utility model, two observations are relevant in the context of today's deliberations. In para 1.2.2, the policy talks about reaching out to the less visible and silent IP generators and holders, especially in the rural and remote areas, who include small businesses, farmers, plant variety users, holders of traditional knowledge, designers and artisans. Again in para 4.6.15, the policy recommends implementation of incentives for MSMEs and grassroots innovators to encourage filing by the said sector. These two observations are significant. If you examine the kind of innovations and designs that these outliers make, you will understand why they are not there in the patent offices with their applications. Some years ago, when I was a part of a UNIDO consultancy, I was touring the MSME manufacturing clusters around India. I found that almost all the machine manufacturers were making adaptations with minor innovations on the existing models to suit the requirements of the industry who ordered the machines. Those incremental innovations can never satisfy the criterion of inventiveness in the Patents Act, and their innovations may never get any recognition. We must recognize one thing, that IPRs are economic tools. The Honorable Vice Chancellor mentioned it's a tool for development, and tools should serve the community. The philosophical justification advanced for strong protection of IPRs is that they are for encouraging and incentivizing innovation and creativity, still a debatable proposition. Post 1990, almost the entire world moved towards a global market economy. The fundamental principle of market economy is that competition leads to a plethora of cheaper and better products. Therefore, market economy encourages competition in all fields, having it to its consumers to decide market of a product. However, IPRs are restricting competition by granting exclusive rights to IP owners, though for a limited period in most cases. However, from the economic angle, there are two justifications for such monopoly. One, inventors are incentivized to reveal their innovations, thereby avoiding wasteful expenditure on reinventing the same. Similarly, creators of literary, artistic, and other works that fall in the domain of copyright can make their works public without fear of misappropriation. Second, the exclusive rights incentivize investment in transforming inventions and original works as marketable commodities. The real role of IPRs, marketable commodities leading to development of various industries. But such protection, to be most effective, has to be conducive to the stage of economic and social development of a country. That means protection should be extended to, I would say, three categories. What the economy is producing, two, what has got a market in that economy, and three, what is acceptable to the society. These basic socio-economic factors have to be kept in mind in the discussions on utility model protection in any country. So far as India is concerned, I feel that the protection of utility model satisfies these criteria. These products are what our grassroots level innovators, our MSME sector, our informal sector, and our technical institutions are quite capable of producing and already doing. We have about 4.8 million MSMEs in the country, employing billions of people. Most of their innovations are not of patentable variety, as again the Honorable VC mentioned. But a utility model protection can boost their business and be an incentive to them to take part in the self-reliant India vision. Honeybee Network, a non-profit organization supporting grassroots level innovation, of whom you might have heard about, in India has documented nearly 200,000 such grassroots innovations in the past 2 decades. The National Innovation Foundation also has documented grassroots innovation and has even drawn up standards for them. Second, these products have a market, maybe limited to India, or in some cases limited to their region. Most of them have good demand locally. Say, for example, coconut tree climbing machine developed by a college in Kerala has demand where there are large number of coconut tree plantations. Third, they are mostly in response to local necessity, meeting the societal need from locally available resources. I remember, those who are in the old age group would remember also, Delhi had a unique vehicle for public transport in the years following independence until the 1990s when the new revolution came in. They were called Fatfat or sometimes Fatfata by the common people because of their loud exhaust sound. Do you know, these contraptions, which could accommodate about a dozen people, were actually made out of the famous Harley Davidson motorcycles mass produced during the Second World War and which were abandoned by the British Army when they left India. And the story remains there. This is an example of Indian Jugaad that met with the societal need for public transport. Another such Jugaad is Mitti Cool. We displayed it in the National Institute of Design for quite long. The low-cost, biodegradable refrigerator made out of clay. It is flexible thinking that allowed the innovator to use millennia-old material like clay, which has always been there, to create a fridge out of it. So these are the kind of tools. Then, so what are the alternatives to utility model protection if you are not going for something special? One, of course, is patents. But the patentability criteria will have to be considerably diluted to accommodate them, or create a system of minor or silly patents. These options are, to my mind, likely to lead to more complexities in a country like India. The second option is designs. But design protection, as per the Designs Act, is for the external features of an article or that which appeals to the eye only. It does not get into the functionality area, whereas utility models are essentially in functionality sphere. For example, the cheap but efficient thresher for the urbanites is a machine to separate grain from stalks and husk, made by Mr. Madanlal Kumawat, a carpenter with an education of class 4 only, from Sikar in Rajasthan, does have only functional design. It's not eligible for design protection. It is in this context that a sui generis framework of utility model protection emerges as a possible candidate. No wonder 73 countries, both developed and developing, have utility model legislations. However, before finally opting for such a law, again, as the Honorable VC mentioned, a number of aspects will have to be thrashed out and examined. A few observations. First of all, everyone must realize that a utility model does in no way undermine the strict patentability criteria that the Patents Act contains. Some are worried that utility model protection will be used by pharmaceutical companies to evergreen patents to overcome our Section 3D. I hold that this is rather far-fetched. Most chemical compositions or technological, chemical, and biological processes are not likely to be eligible for utility model. In most countries, utility model protection is limited to shape or structure of products in certain fields of technology, such as mechanical devices and apparatus. The model is more in the design framework, like the portable roti maker, working on a simple lever mechanism that can flatten up to 180 chapatis in an hour, made by one Mr. N. Bommai from Bukkasandra. I don't know, Yogesh can correct me if I pronounce it correctly. Bukkasandra village of Karnataka. Initially for his mother only. Later he marketed it in his local areas. Be that as it may, the definition and provisions on scope of protection can easily take care of these issues. Then, utility model is not an alternative to patents. Patents need and should continue to be for innovations that satisfy all the three criteria. High-end innovators and companies will always opt for the same. That's what they experience world over. Their target is mostly high-spending international consumers and not the small fish. Utility model is for those local innovators who are looking forward more to local recognition, like Deepak Barali from Assam, who innovated an easy-to-use loom consisting of three components only: a base frame, magnet-bearing shaft, and a specially designed bobbin for the famous Muga silk weaving. It has got 60% enhanced production capacity. So the wonderful concept paper that the IPR chair has circulated, has captured and presented most of these issues. It contains statistics. I was overrushed when I read that 2.14 million utility model applications are there worldwide, and it's a steadily growing number. The international law on the subject is mentioned, and the arguments for and against protection. The program has also been conceived in such a format that these questions are taken up one by one, deliberated upon, and move on. They are open-ended in that the question whether India needs such a protection in the present circumstances itself is left open. The discussants can argue either side. But if such a protection is advantageous, then the usual requirements of such legislation will have to be explored. This includes, of course, scope of protection, period of protection, what should be the rights, and what are the obligations, what are the procedures, and the enforcement mechanisms. So, with these words, I conclude and look forward to a very lively and informative discussion. I hope to come back to the discussions active stage towards the end of this thing, time permitting. Thank you all.
Thank you so much, Professor James. I must say that you have laid down a very clear roadmap for us for this discussion to go ahead. And definitely, whatever points you have said, definitely it opens up our mind to think about in those very aspects also. Now I give this virtual stage to Dr. Dumane, who is our IPR chair, to give some opening remarks on this very roundtable. Over to you, sir. Dumane sir, your mic is on mute. Kindly unmute your mic and yeah.
Thank you, Honorable Vice Chancellor, Honorable James sir, and my dear speakers. I welcome you all here for this roundtable, and with the concept that we need to assess the need for utility model afresh in the changing industrial environment, and if there are opinion against this, they are also to be considered at the same platform. Now, if you consider, as Professor James has said, and he has elaborated upon the developments behind this utility model and the need for SMEs and all that, it was very thought-provoking, and I thank you, Professor James, for this speech. This roundtable is organized basically to reach to certain points where we can recommend whether, considering the present environment of industrial change, we need to introduce IPR utility model, or we continue to neglect it. But the reasons for neglecting must be specified, and I hope this forum will come out with clear-cut indication that utility model is required and are not required, both ways. As Professor James has said, is open-ended, open forum. Now, when we go back to the IP patent law, particularly in the Patent Act 1970 and earlier, and which continued up to 20th May 2003, we never felt need of utility model, simply by virtue that, but there was no inventive step requirement in the patentability, and it was confined to new and useful art manner of manufacture of the articles, etc. And most of the things which we consider now as to be part of utility model might have been considered for patent that time. But that area is over now. Now, second thing, when we switch over to TIPS and then we try to amend our act, and we have to adopt a strict criteria of patentability, that is introduction of inventive step there, the strict criteria, and then therefore all these minor inventions were not considered and are not being considered. So that is the issue. Now, when we are keeping away all these innovations, useful innovations, as Professor James had aptly said, there are so many inventions which could be given protection are left without any protection right now. And therefore, introduction of utility patent was discussion of at many forum, as James Sir has specified during this national IPR policy setting or in discussion paper also. Nothing has happened, and we need not elaborate reasons for that. But now, this is the time when we have to consider the utility model, particularly when the industrial reformation is going on in the country, and we have we are mandated to change ourselves, to create innovation-based society, to create new and cheaper, better product, which are befitting the Make in India, Make for India, and Made in India scheme, which will supplement the Prime Minister's program of Atmanirbhar Bharat Abhiyan and a vocal for local. We cannot escape this if we want progress of India, industrial development. Prime Minister program are very, very befitting to present situation, and therefore, if we want success of all these programs, we need to strengthen our domestic industries. It means we want to create innovation-based products of various types, diversified nature, and of all types. All of them cannot fit in the patent acts now, as Professor James has said. Some major inventions may be protected by patent acts, but other inventions, which are equally important for the holistic development of technology of particular enterprise, will need protection at lower level. This could be utility model. With this theme in mind, and then the recognized view of the experts in the world that utility model will generate creativity and innovation in small innovators, SMEs and startups, etc. And then we will be able to create more patents also if you start initially from utility model. This has been the experience of major countries. So all these considerations will lead you to believe that utility model are required in the country. Apart from this, there are considerations that at present, as James Sir said, with high number of SMEs and startups, how many file patent applications? Very few. And out of the application for patent filed, many of them get abandoned by either at 9(1) or Section 21(1) because they do not fulfill the requirement of Patent Act, because they have no resources for R&D and all that. All these factors need to be considered while we give our opinion for the introduction of utility patent in India. With this in mind, and the objection existing at present for utility model, we have organized this roundtable, for which wonderful speakers and panelists we have got, and we are thankful to Professor James also that he gave such a thought-provoking speech, and that will be a guiding factor for us to proceed ahead in this roundtable. I expect that all the speakers will enlighten us on the issues which are listed in the concept note, and along with how to win over the objections for this. Now, with these remarks, I hand over the forum to Professor Sajid. Thank you very much.
Thank you so much, Dr. Dhumane. Definitely, with your experience as the senior joint controller of patents, which you earlier were, you have really, talked about why this utility model aspect needs to be thought right now. Definitely, you talked about Atmanirbhar Bharat, Make in India, the campaign which is going on, and definitely, if right now we think about it, then we can do something. Otherwise, it will be ignored forever. So this is the opportune moment for us to have a debate on this. Before we open the roundtable, I'll just let you all know the speakers who are with us today. Dr. Anil Varyat, who is the professor and registrar of MNLU Mumbai, he is with us today. Professor Dr. Tabrez Ahmed, he is the Pro Vice Chancellor and Dean at GD Goenka University. Thank you for joining, sir. Professor Prabhuda Ganguly, sir, is there, who is the CEO of Vision IPR and advisor of IIT Jodhpur. Professor Irene Kalboli is there with us, who is the Professor of Law at Texas A&M University. Professor Padmavati is there, who is the Professor of Rajiv Gandhi School of Intellectual Property, IIT Kharagpur. Dr. Gargi Chakrabarti is there, who is the Research Fellow at Max Planck Institute of Innovation and Competition, Munich. And she is also Associate Professor and IPR Chair Coordinator at National Law University, Jodhpur. Also, she is my teacher. Grateful to have you today, ma'am. Dr. K.S. Kardam is there, who is former Senior Joint Controller of Patents and Designs. Of course, Professor James mentioned about the research output which he has created in this very field of utility model. Similarly, Dr. Sheetal Chopra, she is there with us, who is the India lead of IPR advocacy at Ericsson Limited, and also a member of FICCI, CII, ESCOM. She has also contributed in the field of utility model by the way of research. Dr. Saha is with us today. He is the ex-director of TFAC and advisor to CII. Mr. Avinash Kumar is there with us, who is the former associate director of IPR at DRDO headquarters, New Delhi. Mr. DPS Parmar is with us today, who is the former technical member of IPAB and senior special counsel at Lex Orbis. Thank you so much, sir, for joining. Mr. Ravi Bhola, who is the partner of K&S Partners, which is a very reputed law firm at Bangalore. He is also with us. Ms. Archana Shankar, she is senior partner at Anand Anand, which is again a very reputed law firm in IP. She is with us. Partner of Remfree and Sagar, Ms. Ranjana Mehta Dutt, she is also with us today. Thank you, Dr. Gopakumar Nair, who is a very renowned expert in this field, and he is CEO of Gopakumar Nair Associates. Thank you for joining us today. Mr. Ashok Shukla, who is the Group CEO of SPA Group Enterprises, who is member of many committees like National IPR Committee, FICCI, SME Council, CII, and more. Thank you, sir, for joining. Thank you, Dr. Malti Lakshmi Kumaran, who is the Executive Director and Practice Head of Lakshmi Kumaran and Sridharan Attorneys. Thank you. Dr. Miss Anuradha Maheshwari, who is the founder, partner of Lex Mantis. Thank you for joining, ma'am. Dr. Pranjal Fukan, sir, is also with us, who is the Director Strategy of ICTMAE Global and mentor of IIE Guwahati. My teacher, Mr. Yogesh Pai, is also with us, who is the Assistant Professor Law and Co-Director of the Center for Innovation of at MNLU Delhi. Thank you. Very fortunate to have you with us today, sir. Mr. Christian Bunke is also with us today. He is the CEO of Basic Group and Director and Co-Founder of Urban, which is also related to IP management. Mr. Abhijit Rohi, a faculty of MNLU Mumbai, and Mr. Chirag Balyan, who is also faculty of MNLU Mumbai. All these esteemed speakers are with us today. With this short introduction of the speakers, because keeping in mind, I knew that we have limited time and a lot of issues at hand to discuss. I thought it will be appropriate if I just say short introduction. So, first of all, I would like to apologize in advance only if I may cut you short of time. So, my sincere apologies in advance only. So now with this and with the permission of our Registrar Sir and Dr. Dumane and our Vice Chancellor Sir, we open up this very roundtable discussion open, and we'll start up with the first issue at hand. Because we discussed about utility model in India, why it is, because the speeches were about why it is required in India. So our question is, what are the lessons which we can take from on how utility model protection is functioning in other countries? We'll start with the views by Professor Irene Kalboli. Over to you, ma'am.
So, good afternoon, everybody, and congratulations on putting together this very relevant and very important roundtable. When I was invited to speak, and contribute, I said I can contribute primarily on some comparative aspect. And I think, Sir earlier, the speaker before me, has very nicely outlined all the pending issues that at this point India is considering and has to consider whether you are interested in pushing forwards the creation of a utility model system. And the comparative analysis was very much encapsulated in the remarks of the distinguished speaker, because he correctly highlighted the issue with quality, patent quality versus quantity, the examination issues, and at the same time, the shortcoming that a possible use of industrial design could be doing. So in my comparative analysis, and I'm going to be very short, I want to mention to you 3 different models. I come originally from Italy. And why I mention that is because Italy was a pioneer early on, even before the European Union creation of the system of industrial design, in having, in addition to the utility patent, 2 types of models. Italy has protection for utility models and for ornamental models. The ornamental models, in many ways, is the grandfather of the industrial design. The protection that went all the way to the European Union, and through the push, mostly by the Italian, the European Union was introduced into the TRIPS agreement too. There are exceptions, the spare part exception, and so on. But Italy, interestingly, is a country with a lot of design, not just fashion design, but jewelry design, machinery design, car design. And so it's a country that, whether is the IP pushing that type of innovation or that type of innovation needing certain type of protection, it's very difficult to pinpoint in the innovation cycle which one comes first. Is IP really promoting that innovation? Even all the most accurate empirical studies can really prove which one is the chicken, which one is the egg. But we know we need the ecosystem, we need the protection to create and give competitive advantage. And at the same time, we need to make sure there's not too much protection, because that will become actually anti-competitive. So the Italian example of ornamental model that was more based on the ornamentation rather than the utility, and the utility model, which were very much patent B, was so those that could not really fully qualify for a utility patent, and they're becoming more utility model. We should say, though, that in Italy, and that's still the case, these rights, these applications are not actually examined. Like across the world, most industrial design application, even at WIPO, are not examined. There is just a rubber stamp, there is a checks on the formality requirement, and any challenge to the validity is really done with litigation ex post. But that was the case also for the traditional utility patent in Italy until not long ago. That's been the case in many countries until not long ago, that we didn't really have anybody opening the files and checking the validity of the claims. There were some countries like the UK and the United States that has a long tradition of actual examination of patent, but a lot of other countries never did. Then they start to do, and now has become much more a common thing. So if we import the system of Italy into India, would that create a ballooning of a lot of small businesses going and running to apply for utility model because it's faster, perhaps a bit cheaper than the full-blown utility patent, and creating a problem of quantity versus quality. Considering the numbers in India, that's very likely. And to that, I think that India should look at China. China has now #1 patent filers, but let's go deep and check the quality of the stuff that is actually patented in China. Numbers, again, don't mean quality. We know that China has design patent where basically a rubber stamp, and a lot of people were applying for the design patent to actually have a right, but then possibly to commercialize it, get some financing, get it as use it as a collateral for banks. But in reality, the actual validity in terms of quality of this piece of papers was often no more than just a piece of paper. So does India want to have this, paper collection with no examination? Because if one wants to do a thorough examination for utility model, one has to have really at the national level, at the various provinces, district levels, very strong examination also for this utility model to avoid inflation and bad quality. So I think, the Italian model is useful to see options, but the Chinese story in terms of abuse or, too many of these rights might also be some red flags. Then I want to look at the American system. America has utility patent and design patents. The design patents, though, are fully, it's a lower in terms. These are those inventions that will not technically qualify as first law patent, but usually they have simpler claim. They're more based on the functional design, and then like golf clubs sometimes, or design. Also, remember in the United States we don't have industrial design, so there is no sui generis protection for industrial design. So either we can use copyright or trade dress, or we need to use design patent for zippers or buttons or things that are not 100% qualifying as patent, but they can be design patent. Those are not granted just with a rubber stamp. They're also looked carefully. And so even though the examination might not be as accurate, I think in the US we have never seen the inflation phenomenon of design patents that we have seen in other countries. So why that's the case? I think that would be an interesting proposition, but to create a system that works will require cost. So is the current system of industrial design not working enough in India? That we really need a invention light system, because these design patents are a lower level of invention that needs to be protected, and what's the enforceability of that? So I think we're looking at the Italian system, the Chinese system, the American system. We can learn some. I don't want to use the word lesson. You say what lessons from India. I think India can teach others a lot. What suggestions could be taken, for India. Then I would look at the European system. Europe has a European patent that is not yet harmonized, even though we should have a community patent. There is no harmonization of utility models. There is industrial design. And the industrial design at the European, the EU IPO level very much includes a lot of what I would think you would include under the utility model system in India. So one of the possible suggestions is there any way, rather than have to invent a whole new right that can add on a lot of bureaucracy, perhaps that's useful, but is there any way to perhaps really looking and reopening the law of industrial design and amending that law to include, particularly since there is a registration process, to include a higher level of potential examination or something that could serve maybe better. So I think India has the following option: doing nothing, which sometimes is actually the best option, creating a whole new right, or adapt and perhaps amend the existing laws a bit more, both from a substantive protection standpoint and then administratively, how you will protect, how you will examine, how you will create opposition, potential appeals and so on, how you can deal with, the potential.
Professor Irene, could you kindly wrap up, ma'am?
I'm done.
Sorry to interrupt. Yeah.
I'm done. So I think these are really the suggestions that I think India could consider, but thorough studies of potential economic impact, both at the IP office level, so how much it would cost, and then how useful it could actually be real. You don't want a new right unless you think it's truly potentially useful. I'm more and more, no more rights unless they really are more useful than the cost they can bring. Thank you very much.
Thank you so much, Professor Irene. Of course, Mr. Christian would like to speak on this because already he runs this IP management system, so he must be the right person to speak on the cost, time, consumption, etc. Over to you, Christian, please.
Thank you so much. So I thank you so much. Lovely to be on board on this call today. I've worked with IP in India for 16 plus years now. I come from a slightly different position. I work a lot with startup companies and new technology companies. We know that there is research out there from the UN and for the International Center for Trade showing that incremental innovation is supported by the utility model. We know that Japan, Korea, Taiwan have all benefited from this, having more of an incremental innovation taking place. We have a metrics when we do analysis of Japanese patents that normally 6 in the sort of electronic space, 6 Japanese patents become 1 PCP patent. Similarly, I feel that the system works very well in Germany and in China. Australia, maybe not so, because they're also looking to remove their utility model. Just to give you a very brief summary, we had someone call us on Wednesday and they asked us if we could file a utility model in India from a PCP application. And we had to explain to them that no, it didn't exist and it would have to be a patent. And I would expect that it's because they felt that their patent might not fill the criteria of being a full patent. Germany works really well. We have seen cases where people have converted their European patent into a Gebrauchsmuster so that they can strengthen their position in negotiations when that patent is being forced under opposition. In China, when we have gone into China with some of our startups that need investment, we normally file parallel strategies where we file both the utility model and full patents. So we get granted rights very quickly. We can therefore back up the investment of big money. And then here comes the finishing punchline. I think all of you you are much more experts on this than me, but considering the world is moving to software, technical effect is now accepted in Europe. We can get granted software patents in the US and in Europe and in South Korea. We really struggle in the UK. I understand there's a strong connection between India and UK historically because of the legal frameworks, etc. However, if there is some way to start looking at fast grants, non-examined, and maybe opposition proceedings, maybe a way of re-examination like you have in the USPTO for patents, but technical effect looking at software, that would really make a difference for Indian startups in the future. And India is software, China is manufacturing. Thank you very much.
Thank you. Thank you so much, Christian, for your views, and definitely talked about software patents also here. Now I would like to request Professor Prabhuda Ganguly to give his views.
Okay, I'll be very brief because there's so many speakers. The first part I think I need to put in is what is the economic impact? There's no economic impact. There's no point bringing another law in a whole basket of other laws of IPR that we already have. And so that's the first part. And I don't think there is enough evidence and I would like to slightly differ from what Christian just mentioned. There is very little evidence of really good utilization and enforcement and valuation of utility patents in many of the countries. Point number one. Point number two, I would like to state that the whole subject matter that is to be covered by utility patents is a very small set of inventions. The question is, for mechanical, if you go into history of all these, most of them have been for mechanical devices and electronic devices, but of those type. It's more coming from that standpoint. And therefore, for such a small sector of the sector of the innovations and technology, do we need another law? Right? So we need to look at that. We need to evaluate that part. Third, there's very little evidence of any great enforcement of utility patents in most countries. Germany, yes, to some extent, but other countries haven't done very well on that. So looking at all these factors, should we be looking into another law? Point number one, especially when our patent system itself is having such huge backlogs. We have now coming to software, and that's where I will end. Coming to software, our software, if there is, if you go to section 3K of the Indian Patent Act, which says that software per se is not patentable. So therefore, when you come to the non-technical aspects of the software, that's anyway protected by copyright. So what we need to evaluate, we need to debate what is going to be the real value of this new law. I'm calling it the new law because we don't have one such law. So what is going to be the value of that in the country, except that it's going to add one more in the basket of IPR laws? I will stop here, but I'm a very strong contender that if we do not have great economic benefits, there's no point making another set of legal gymnastics out of this and getting legal experts into this whole gymnastic process. Thank you.
Thank you so much, Professor Ganguly. Definitely, you've raised a lot of questions. I'm sure some will be answered in this very session. Over to Dr. Kardam for his views. Sir, you may unmute yourself first, sir. Your mic is on mute. Still, sir, your mic is on mute, sir.
Okay.
Yes.
Good afternoon, everyone. I just slightly differ with Mr. Ganguly what he said. Although I can't say whether this is the right time to introduce utility model in India or not. But I have 2 points to just differ with Mr. Ganguly, that he talked about the economic importance of utility model. And he himself has admitted that there's no much data or empirical research whether the small innovation has impacted any economically or to a country or not. But you see, our law, if I feel, my personal opinion is that we are continuing with the law which has been provided under the colonial system. So colonial system provided us a patent system, and it provided on trademark law. It provided later on that industrial design law also. But never thought there could be any law, because Japan identified in 1905 the importance of utility model, and similarly Germany, before that Germany started realizing the importance of a utility model. Why? They know better, because they utilize the utility model by copying the Western innovations. The Japan. If you look at the research, they copycat. They were known as copycat. They copied the Western research, utilized in the form of utility model, and you see the utility model application grew like anything up to 1986 or 87, and thereafter the utility model application came down in Japan slowly, and now today I don't think more than 10,000 applications a year they are receiving. So it has come down drastically. But the fact remains same that they have utilized this particular law to the best benefit and best possible extent before they became a technological giant. Japan now don't think about the utility model, but now any invention, high-end invention are being carried out in Japan. So whether it is a pharmaceutical, whether electronics, they are an automobile, they are number one. This is the story of Japan, how Japan has utilized the utility model. Secondly, Dr. Ganguly talked about the huge backlog. Now, if you realize now the backlog is coming down. So our examiners are worried if the backlog is clear, what they will do it after that. So that, and because now in the chemical sector, now chemical and pharmaceutical, we are examining the application of 2020 also and to December 90. So the examiner are worried what to do now if the backlog is over, what to do. So many examiners, there is no work. They are worried, but they have a lot of work. As I told them, you have a lot of work when you bring efficiency, quality in the examination, and you improve your report and search system, and then I think a lot of application will come in the filing will increase tremendously. So I think, but my question is, if it is not the recommendation of the Roundtable Conference, and government thinks in its own way. There was a group, as Mr. Professor James mentioned, and I was also part of that group. And the discussion was whether to implement utility model in India. And that time, everyone was, even Sheetal Chopra might be there. I remember FIC representative. So the Joint Secretary that time, he said, no, we are struggling with the pendency of the patent application. We don't want another. We don't want to change the focus of the examiner. We don't want this law because this is highly unreliable and there is no enforcement provisions. Enforcement is another problem. So that time it was rejected. But I feel that now, as James explained in his address, that now 40% of the contribution of the economy is by the MSME. And today, if you look at in India, the MSME application hardly, may not be more than 500 to 1,000 applications. Dr. Dhumane may be knowing because I don't have the latest figure because he was in the office. So he used to compile the data. So he must be knowing how many applications per year filed by MSME sector now because we have a separate category of MSME. So may not be more than 1,000 applications from MSME. When we receive a 50,000 application and 50 out of that 1,000 applications are meaningless. And even it may be less, maybe more, not 500 also. So but if we want to, because there are a lot of new products being developed by MSME based on the utility functionality, but they are not protectable. China has a huge number of utility model applications today, around 13 lakh applications. So 1,000 applications in terms of 1,000. So, and they continuing every year they are increasing, not only utility model, but also design application and patent, of course. Korea is another example how the Korea is successfully utilizing the utility model system beside Germany. And US has its own decision whether this particular patent should be granted under patent or under utility patent. So they have different, all thought together, all together. So considering and once the government decide that yes, India needs a utility model, because now we feel that utility model is a very old thought. India is progressing very high. So in terms of innovations and other things also, economically also. So I think most of the view in the government is that the India is not in a position right now to introduce the utility model because it has crossed that particular stage. But if you look at the application file in India, patent application, still not that much. It doesn't reflect India's capabilities of innovative activities. It does not at all. So India, I don't know what the reason, Because every year, if you look at it, more than 2 lakhs research papers are published every year from India. But now, I mean, out of 2 lakh research papers, only 30%, I mean, maybe 20,000 patent application altogether. Indian application I'm talking about. So it doesn't really reflect. So we have to first convince the government whether they require, because the MSME, we are talking about the MSME to protect their innovation, but whether MSME really want it. So first round of things should be, let us have a discussion with MSME whether really they want this kind of law to protect their innovation. And then, of course, government can think. Even government, without any discussion, if they want to bring any law, they can bring it. But justified law has to be based on some recommendation and the requirement of the people like MSME. Still, I feel that if it comes, I think it will play its role. Although it is highly controversial in the sense the enforceability and the validity, because there in most of the countries there is no examination. Only one or two countries there is an examination system. They conduct the novelty search, but most of the country do not have the examination system. Just formal, based on the formal examination, these patents are granted, utility model granted. But I think there was some issue relating software. I may make it very clear that in the country, most of the country, these utility model are used for protecting the mechanical devices, neither pharmaceutical nor software. So I think these kind of apprehensions may not be there when India think of introducing the utility model. So with this, I think I conclude because a lot of speakers are there. So thank you very much.
Thank you, Dr. Kardam, for your views. Of course, you have done a very comprehensive study. Is it the right time or it is not the right time? Definitely, time will tell. And of course, a lot of consultation is required with the various stakeholders, not only with MSME. It is not a law which only MSME will get the benefit of, but other innovators are also there. So here I would like to bring Dr. Sheetal Chopra, who has also worked a lot on this very issue. Ma'am, could you give your views on this?
Am I audible?
Yes, you are audible, ma'am. You are audible, ma'am. Please.
You are audible. You are audible.
All right. So thank you so much. First of all, thanks to MNLU, Dr. Dhumane, Dr. Sajid for inviting me. And I'm super excited to be in midst of all of you. Just a small disclaimer, whatever I say are my personal views, and it has no relation with the company to which I'm affiliated to, because the company has yet to formulate opinion on this. So whatever I say is actually based on the research work that I carried out back in, during my PhD 2015. Can you see this huge book?
Yes, we can. Yes.
So this is the research work on utility model, and I'm so thankful that Dr. Kardam's research work that he did in Japan moved me a lot, that this is the area that needs a bit of more exploration. I think, this decade has been announced, was announced as Decade of Innovation. And now when it's just few months left for this decade to be over, Indian government has now launched Atmanirbhar Bharat. And this shows a very clear intent of our own Indian government that we want to emerge as an innovation hub. And there has been national IPR policy, slew of awareness programs just to support domestic innovations. But when we look at the patent system, we all know that, number one, that commercialization of patent has been less than 3%. Second is that the majority of filers has been from the foreign countries, and it's less than 32% or 30%, which our own domestic citizens have been able to utilize. So at least this gives us a prompt, at least a pin that why don't you think about something different, which is more suitable for domestic innovations, and utility model is one such area that could be looked at. So this question is about how is utility model functioning in other countries, and there are 93 plus countries which have the system. since these countries decided to have this system, itself signifies the significance of this system at the first place. So I don't think it will be very right to just reject it on the face of it, just maybe on the point of less capacity building or so many other laws or so on and so forth. I'll just share with you a few examples, one from Japan, China, and Australia. Of course, there are a lot of research points that can be found from this research work. So Japan, before adoption of utility model, there were less than 1/3 of all patent applications that were granted to Japanese nationals. Almost a similar situation that we are in India today under the standard patent system because of very high level of inventive threshold. And this really discouraged Japanese inventors of small inventions. And that was the time when the expenditure towards payment of royalties was too high because it was largely imported. Therefore, the need was felt that, let's have utility model because there was something in Germany already. And the system was most 90% borrowed from German utility model system. The moment utility model was adopted, what it really helped is to make Japan technologically highly advanced. Initially, total number of domestic filings under UMs were very huge. And over a period of time, after a few years, maybe after 60 years or so, this started decreasing. Why? Because this country grew up technologically advanced because they were able to use system of utility model. What used to happen was, use the technologies, the high inventive threshold, adapt, and modify the existing technologies for the local population. And Japanese inventions generally included, that time daily commodities, but now we know where Japan is. And this has really boosted spirit of inventions. Let me just share with you one stat. It says, stats reveal that utility model is exploited or commercialized 50% in higher amount as against the standard patent system. So where we are all struggling with the fact that less than 3% patents are being utilized, these are not getting commercialized, public is not able to utilize that patented inventions, is coming at a cost of something, at a social cost. Utility model has been commercialized more than 50%. I mean, this itself reveals the excitement that people have, the excitement that inventors have after that UMs are granted at much quickly and with a greater ease. Stats also reveal that Japan was able to earn revenues by out-licensing of their UMs to other countries. And just 1 year data shows 356.6 billion yen. So these are very encouraging for sure. Let me just share with you China's example. Grant of UM helped in increasing GDP of the country, and it helped in helping small, poor, and capitalized business. The year utility model was instituted, GDP increased from 10.9 in the previous year to 15.2 sharp, 5-point increase. Just the moment it was implemented, and so much of domestic inventors, they started using this system. Rate of commercialization of UM in China is 60%, which is much higher than the standard patent system. And we all know, where China has become remarkable in terms of a lot of foreign investments. It is now that, because of copy theft, because of IP theft, that trust is lost. But initially, the quantity really helped the country to grow. And of course, if it is coupled with the quality, like the erstwhile professor said, I think that's the best thing to have. Last point from my side, from Australia. Here also, stats shows that UM is exploited 60% more than the standard patent system. And there is another report which suggests that innovation patents in Australia aided in absorption of new technologies, which were developed, of course, overseas. Thus, UM significantly influenced the technical efficiency of the firms. So taking cue from here, I'm not suggesting whether India should have or not, but I think it's a good idea to look into what other countries and how they have benefited, and if something that we can learn and make our systems more robust.
Right.
I think
Thank you so much, ma'am. Yes, thank you so much. You definitely gave a lot of perspective from different countries. And of course, India should also give chance to the domestic people to innovate. And definitely, utility model can help in that also. With this, we move on to our next issue, which is also coming from the first issue only. The issue is whether the utility model protection is needed in India under the present industrial environment. So straightway I open the floor to Dr. Saha, Dr. R. Saha.
Thank you, Professor Sajid and Dr. Domane, for including me on this panel. Let me repeat what Mr. James said, that in 2012, the working group, according to me, it rejected the idea of having a utility model legislation in the country for whatever reasons. Now, today we are 2020, just about 6 years ahead. And what is the evidence? What are the economic reasons what we think that utility model should be introduced either now or after 10 years? If some new evidence has been generated, I think that should be shared with people who are interested in this area. Secondly, somebody mentioned about NIF, and I handled NIF when I was in the government. And initially, the idea was that NIF, by commercializing the so-called frugal innovations, and become self-sufficient. And today it has been more than what? 18 years? It has not become self-sufficient. Hardly few frugal innovations have gone to the market. So let's be careful on these kind of ideas and these kind of slogans. The other thing which has been said, that utility models will encourage incremental patents. Now it is all going against the philosophy of Government of India, where we have been arguing in all forums that Indian Patent Act does allow patenting of incremental invention. It does not say that incremental inventions cannot be patented. So I think there is some kind of a contradiction when we take this kind of stand. The other thing about quality of inventions, I would like to 2 or 3 points. One, of course, since it is only novelty-based and not inventive-based, the quality of patents, especially in the global market, is going to take a big beating. Secondly, our educational institutions and research institutions will find an easy way of filing utility model applications and enhance their biodata, and which is not in the interest of the long-term research of the country. I take this point very, very seriously. And on the global front, utility patents are not going to add any value to any innovation or invention. So whether you talk about licensing or you talk about any joint research, any other thing, the utility models are going to have very, very little contribution to make. Now, it is very clear that some of the technology area, like biotechnology, drug, pharma, semiconductors, software, computers, there's no place for utility model. But let's also at the same time realize that this is the direction in which the world is moving. So are we going to talk about some devices which had little meaning, and now we are not looking at these things? So the point is, all steps what we take should be in the right and positive and progressive direction. Now we all know our IP infrastructure, including courts, is under big stress. Well, yes, the patent examination is improving, but still, other day I was discussing in Gujarat, government, other people, and some startups said that the startup first FER action is being taken after 10 years. So let's be little, introspect ourselves also while we make such kind of claims. Now, in the courts also, we are having these delays, and we know MSME is having a big problem in handling these disputes. Now, with this kind of utility patent or utility model, I suspect that the number of disputes are going to increase by manifold, and this will place more load and more responsibility on our legal system. Now, imagine in the Gujarat, the commercial courts have been taken away from high courts and they have gone to the district court level and whatever level. So as it is, we are having a problem of resolving IP disputes in the courts. So if we have one more thing, and with the assumption, because I think the note which was circulated, it also said that they will increase the number of filings. Since there is no examination, all of them will be granted utility patent. What happens? So this is another issue, I think, which have to be kept in mind. And with the introduction of utility model kind of thing is going to create more confusion in the minds of the judges, in the minds of the inventors. Remember, I started the awareness program back in 1995. It is not 25 years. It has taken us 25 years to explain to people what is the patent, what is novelty, what is obviousness. And suddenly you tell them, oh, no, obviousness is not important. And you can go just by novelty, you can get some rights. So we have to be careful on that. And the other red flag, which I would like to highlight, is the moment we have a system like utility model protection, we will have flood of applications on these devices coming from China, coming from Korea, coming from Thailand, coming from Taiwan, and so on and so forth. Back in late 90s, there were applications filed by South Korean companies on a scooter stand, cycle stand, helmet box. These are the cases of utility model protection. And we were nowhere there. There was no Indian company. And so this issue was also taken up in CII 2 years back, whether we should request government to reconsider. After that 212, when it was decided that utility model should not be there, and we came to a conclusion that utility models are not required in the country because the industry association and the members did not feel that that kind of benefits are going to accrue to them. Now, lastly, I would like to say that we should think forward. We have got a robust legal system which is competitive. More is required to tell people what is to be included in the application so that they can be granted. And let's not look back and follow the example of China as far as the utility models are concerned. Can you believe that even machine learning applications have been granted utility model patents? That's in China, happening in China. So my request is that we should look forward. We should do more homework. We should do some research before even talking about whether utility model protection should be introduced in the country or not. Thank you.
Thank you so much for your views, Dr. Saha. Of course, we have to be very objective in deciding over this very issue. Until we see patent filing is very less, and Indian domestic filing particularly is very less. So definitely we have to find the reasons and the way out also. So over to now Professor Dr. Padmavati for her views.
Yeah, very good afternoon, good evening, good morning, whichever is the zone in which the panelists are. It's great to share a platform with all these great personalities. Well, I think this is a very important deliberation.
Excuse me, ma'am. Can you readjust your camera?
Okay.
Because we are not able to see your face.
Okay.
Yes, better.
That better? Yeah, I'm actually working with a tab, so yeah. Is that fine?
Okay, fine.
Okay.
Okay.
Yeah, maybe is that fine?
Yeah. Yes, this is perfect.
Okay, great. Yeah. So I think this is a very important stage at which I think two things are happening. One is that a relook at whether India needs a utility model protection. Another is are we on the path of looking at a law? When you send me the topics, first thing that occurred to me was to be on the point number 2, which talks about are we ready from the point of view of is the industry ready for it? Well, there are two things that I would like to focus on. One is on the jurisprudential angle of utility model protection. Is that certainly they form the second tier of IP, compared to patents, and in certain industries it is relevant. Now, it's very difficult to say going forward how we are going to see this utility model protection in the country. But are there compelling reasons that we need to look at this topic right now? Yes, maybe. Because remember that intellectual property has always had an economic basis. if you talk about patents, trademarks, or any of the other form of IPs, some of the IPs have socio-economic basis as well. Are we gearing up, or rather is our industry, gearing up for utility model protection? I don't know. I do see a lot of MSME clusters. The mode of the country or the mood of the country, both are set into the startup ecosystem, innovation ecosystem. I begin to feel that somewhere you are going to have the innovations which are going to have the level of obviousness is going to be high. Given that scenario, a utility model protection may be desirable. That's one thing. And if you look at it from the patent system point of view, today we are at a technology where manufacturing has undergone a severe change. We talk about manufacturing in a very, very different context. Given that scenario also, if you see, the high-tech manufacturing, I would like to use the term high definition versus redefinition. You see, if you look at high technology, the inventions, India needs time to catch up. But redefinition, yes, we have scope for that. Given that, again, I don't want to get into do we need a separate law, but is the stage getting ready? I would say, I would believe that the stage may be getting ready, and understanding whether India needs a utility model protection, I think we are at the right stage, because we do work with a lot of startups. We work with weavers. We work with people who are craftsmen. And there we are looking at, what kind of technological solutions can help make a small change, improve their market, in the competitive market space. That is where we are looking at what you call the, typically what we read under Section 21J, economic significance. But then they are not high on the inventive step. There's no inventive step in that concrete sense. So to encourage these kind of small innovations, I would believe that if you look at the philosophy of the IP system that talked about, private reward versus public disclosure, and if we do believe that IP system has really fostered, the market and fostered socio-economic basis, utility models do also give that basis. I would believe that it may not be in the very immediate future that we would need a law, but yes, there is a need for serious thinking, because our MSMEs may be getting ready with some innovations which will not qualify for inventions to be patentable, but certainly utility models are possible. So what about that industry? I'm just wondering, that makes me think, that maybe we need to really look at all these redefined things, low on innovative strength, but certainly have market value. Patent law has accommodated that under 21JA, the economic significance part, where if you look at the inquiry of 21J has two inquiries. One is the objective, another is the subjective inquiry. And if you look at the Indian Patent Access, or economic significance, or both. So we have somewhere, I would believe, the threshold has been set for different parameters so far as inventions are concerned in relation to inventive step. So these are my remarks. And when you really work very closely with the startups, you do wonder that how is it that they can leverage the market? And if you really want to justify an IP system that has value, one needs to really look at this industry as well. And that's all. That's all I have. I don't want to consume more time.
Thank you so much, ma'am, for your very, very insightful views. Now I'll request Ms. Archana Shankar to kindly give her views.
Thank you, Sajid. I'm going to keep it very, very short. I was a huge proponent at least 10 years ago for having a utility model legislation in the country, because that's when we all started talking about the Jugaad invention. But now when I look at the statistics, as Dr. Prabhuda Ganguly said, and Dr. Saha also kind of spoke about it, there was a recent release by the Controller General on 18th of August when we looked at the number of innovations or patents that are being protected by startups. And it's very unfortunate that those numbers were very disappointing. And we're talking within 5 years, the numbers have increased from 309 to 3,000. approximately 3,000 applications that have been filed. So in that sense, I do feel that it's a very disappointing number. So are we really, my views are very, very kind of straightforward as a practitioner, that are we not late for a utility model legislation today? I mean, countries like Germany, Japan, China, they introduced utility model when they really needed to give a lot of impetus to the domestic industry. So I do feel maybe we're late because we have been like Dr. Kardam worked on a paper in 2007. We're already 12 years since the time he collaborated with the Japanese Patent Office to write that paper. 12 years down the line, the technologies have moved way ahead. I think the second point that we really need to talk about is that when we do talk about small SMEs and MSMEs or startup companies, you really need to examine where is the research all happening, which would warrant a protection under the utility model. And if you really look at the startups, I think most of the innovation is typically happening in the software industry, which as on date is not even protectable. Recent order, just an update for everybody. It took Farid Alani case, which took 19 years to get a patent. He struggled for 19 and a half years after going back and forth from the Indian Patent Office to the IPAB, back to the Patent Office, back to the High Court, back to the IPAB. That's the kind of time we took. So I think it's more that are we ready for these kind of a utility model legislation rather than just calling it a petty patent or a minor inventions. I would agree again with Dr. Prabhuda Ganguly that without any economic data in terms of its value, because the kind of people who would be utilizing the utility model legislations would not be the large innovator companies. They would be pretty much the smaller companies who may not even have the resources to, after having effective protection. So you can get a protection if it's only about numbers. Yes, you will have a protection. You will have a utility model legislation. But how effective would it be when you go to enforce them? And would they have any resources for enforcement? One, litigation in India is not that simple. It's not easy. It's not cost effective. And it takes a lot of time to get appropriate relief, considering that there is only 8 to 10 years of life left. Lastly, I think there would be, when we do talk about utility models, we do talk about minor improvements. And when we talk of minor improvements, we do have to bear in mind things like patent of additions that we have. You may be protected under the patent law, and then you have another legislation, a utility model legislation. So what are the kind of commercial benefits, such as cross-licensing related issues, conflict related issues, subject matter protection, that one really needs to evaluate. If we're only looking at mechanical patents or engineering products or products with some sort of functionality, I would say that maybe for that small percentage of innovations, like NIF has effectively utilized the patent system, getting another utility model at this stage, I would feel that we really need to revisit it. Had it been 15 years ago when we really needed it, today India is innovating in 5G technology, in the software area. I think we've moved a lot, IoT kind of, IoT and internet, everything of that kind. We are moving away from, these hardware related products, although there's still a lot more, but if they are hardware related or product based, I think you could still see if we can kind of get a protection under the existing system, or maybe a design protection, or maybe some, I would not say a no to utility model, but I think it's time we revisit this issue with a lot of data. We've got sufficient time. We had sufficient time, almost like 20 years. The government, I know, was against the utility model legislation, because that was a statement, I think, made by the then Joint Secretary, Mr. Rajiv Agarwal, that it's a clear no. And this was like a couple of years ago. It's a clear no for India for a utility model legislation. So what has changed since then to date, so as to now introduce a utility model? Certainly not for creating jobs at the patent office. Like Dr. Kardam said, that once we run out of pendency, we really don't need utility model legislations to take that place. Thank you.
Thank you so much, Ashna ma'am. So over to Ranjana ma'am for her views. Kindly unmute yourself, ma'am.
Yes, thank you, Sajid. And I was just hearing everyone. We have diverse and we've been debating this since 2010, or rather prior to that also. Since 2010, I'm actively participating in this topic. We have various papers, we have various studies. DIPP has done studies, so we have all done. I mean, it's not that there's something new which we are going to debate on. We have enough data. We have legislation in other countries which have been discussed and deliberated upon. So what's new in that which we are going to talk? I think what new has happened is in the current government, which the measures which has been taken by the current government, the movements which have been taken by Mr. Prime Minister, like the Make India movement, the kind of SMEs, MSME we have currently in India. You know, I was just reading a few days back. I mean, Dr. would be the right person to comment on that, but NIF have got a database of innovations or ideas where they have got more than 100,000 ideas or innovations registered with them, but only 128 or 25 applications, patent applications have been filed so far in India. Then why is it so? There's a potential, there's a utility patent regime because of Section 2(1)(j), because of Section 3 of Indian Patents Act. Those are not subject matter of patentable invention. So if we have to promote the Indian industry, and if you see the worldwide scenario as well, you know, I mean, Germany started in 1800. But it was basically keeping in mind the domestic buyers. There were foreign applicants. It was basically to promote and support the domestic industry and the phylum. So say in Japan, you talk about in Japan now, if it's utility patent is going down.
Ranjana ma'am, your voice is breaking, ma'am. Can you switch off your video?
I'll switch my video. Wait.
Yes.
Okay. Is it better?
Yes, yes.
Yeah. So what I was saying, that we have deliberated, we are deliberating since last so many years. So the first and foremost thing, I've heard my seniors as well, those who are for clear no for utility patent, but at the same time, we need to understand and come up with the reasons why no. Why we cannot. I mean, it's not like that any other law coming to our kitty. It's like that, you know, if we are supporting MSME, if we are supporting startups, where are they going to get the protection? They are not going to get the protection under patents law. We have to create some sort of protection for them. How we can do that, whether we can incorporate it under the Patents Act. If we do not want to dilute the Patents Act, then we can have a separate legislation like there is in other states. We can have utility patent law. But that is something which we can deliberate, you know, the term or the other modalities or the enforcement issues. That is something secondary. But once we have to come up unanimously on one thing, whether India is ready for that, I think this is the high time, because the kind of revolution or the industry we are having now, where you know, the more than 25 lakh MSME have been registered, and there are many more which are not regulated or registered. So it's not dearth of innovation in India. It's that they are not getting the right kind of protection. There are no means for them to get the protection. So I would say that yes, India is, I mean, should not be like I said, like the for utility patent. You know, it should be like something PPA, where, you know, when we have started, or we have joined hands with Japan for this project, we are already backlog. So it should not be already late, but I think there should be a serious discussion on this.
Definitely so much, ma'am. Definitely we need to find this space for Indian innovators also in this whole IP regime. Over to Mr. Parmar for his quick views. Mr. Parmar.
It's my great pleasure to be here with the old timers like me and the young blood. I remember when we started this exercise somewhere in 2010 when I was part of the patent office. And I still give a credit of this utility discussion to V. Bhaskar. And he went an extra mile to trigger this discussion. And I was part of that discussion paper which was prepared, meticulously prepared, and which now stood the ground so far because everyone is quoting from that paper only. I can see it. And I know a lot of changes are visible, both in the perception of the young generation as well as the perception of the old generation. But still, I feel that an opportunity is there. Whenever change of perception is there, we should take it as a challenge, or we can take it as an opportunity. Either we want it or not, it's a different thing. But at least an opportunity is there given by MNLU to discuss this and bring it forward. Because 2011, long time when we said rejected, yes, no problem, doesn't matter. Anything can be policy driven, always when you are in the government. But this discussion should now conclude. Because we cannot keep this discussion open for such a long time. And I feel, because I was part of those discussion paper also, and I have discussion with other people also during my whole lifetime in the patent office as well. I was just looking for that this change will definitely impact SMEs, IP professionals, IP administration, and grassroots innovators. This change will impact everyone. The reason behind this is that we should not call these gross innovations as jugards, which has been or second line innovation. Perhaps we are belittling and discouraging those inventors. These are petty inventors. Does not mean they are not inventors and they are not doing inventions. Better, these inventions are differently enabled inventions. Differently enabled. Means they are enabled inventions. They are finding solution in the technology handicap faced by them. These inventors are the grassroots workers in the remote technology starved locations. India, sometimes we call them remote locations. Technology is not available, or sometimes the finance is not available. And these handicaps are situations somebody has to find a solution. And these, in fact, are the important bridge for the existing gaps in the technology in the remote locations where it will certainly take some more time to reach. And when you find this technology is missing in those areas, local people will definitely come forward with solutions as James was mentioning, Mitti Cool or some other devices which has been there, already there. But this is a bridging gap arrangement. And Mr. Kardam was also telling that Japan has done it and now no nothing is there because they have bridged the gap. Basically, they have used the system to bridge the gap. Which invention and what invention is not that important. Bridging the existing technology gap required for a better development of a society is important. Second point which I want to make it is that rapid growth of patent shields and the high-tech firms is silently coercing these SMEs. These SMEs are always facing some problem from high-tech companies. They are feeling that they will be caught and put in the infringement mode. So these SMEs are now being silently pushed into these petty solutions for their day-to-day problems. And this suggests that small and new firms will increasingly struggle to defend themselves in the marketplace. And for that, patent is out of question because they are not able to find enough finance, there are not enough money, and long prosecution process, as Madam has mentioned, some 19 years have taken to get a patent. So that way they are not into that mode. They start up and they close sometimes and move on to some other things. And it will be necessary that they should be provided an IP right weapon through this petty patent route. definitely they need this. They need this. You cannot leave them without any mode of support. So they have to be strongly supported on this, and definitely this will cause another problem. The petty payment shields will cause another problem, because some people, as I said, the legal mechanisms will be there for allied technologies will come forward, and they will take patent for those and consolidate their power. As Shita also mentioned, that possibility is there that big companies will look for the biggest areas, but smallest companies will look for lower technologies. They are trying to bridge the gap. They are not overpowering those technologies, which means the battle of patent is not over. It is starting over, and this challenge is still existing. The petty patents will definitely provide a security net to the inventors who are looking for transforming this battleground into a competitive innovative, and this will also affect the jugaad people as well. Indian patent is already market is visiting that kind of sea. We can see that is why we have slogans like Atmanirbhar Bharat, made by locals, and let us encourage on-the-spot solutions and stop-gap solutions to bridge the technology gap faced by the local Indian inventors. If skillful intermediation in the market retainer is done for the import purposes, and Make in India will definitely jumpstart the skill in India and work an instrument for permanent market change that will transform the global economy geographically and competitiveness in Indian startups. And one thing which I want to tell you now in the COVID time, we have seen the jugaad invention, which petty inventions, so many. Without touching, you have to push it and get this sanitizer in your hand. Who has done it? Local inventors. This is the kind of things which has been developed in the economy, and these inventors have now grown in number. So many solutions have been found. Without saying much on this particular issue, so we can look at it that we have an opportunity that MNLU now looking forward and take at a policy paper at the level which we are looking at, and let us look at. We don't look for what will be protected and what not will be protected, but let us take a step forward that we look for the people who are in the area who are looking for to bridge the technology gap. Thank you very much. On this
very right, sir. Thank you so much, sir, for your views. Very rightly, you said like those challenges are there, but only because challenges are issues are there, we cannot just ignore this very issue altogether for long. It has to be decided upon now. So over to now Professor Tabrez, sir, for concluding remarks on the second issue.
Okay, thank you, Sajid, and also the Maharashtra Council for inviting me for this very important deliberations, and also sharing the dais with a lot of big shots in the IPR world. My views are that because if you see the cost-benefit analysis, I think we are going to get more benefit than kind of the losses if you try to implement the utility model patent. Because seeing the example of the, Japan, Germany, and all these places, now they are doing very well in the IPR world. But if you see Indian scenario, if you see the patents per million, it is just 35 in India, where 290 is America, and 889 is Japan. So why, if you compare one Indian with one Japanese, even Japan is very, very innovative, very, very potential person. And this scenario has come because they have got hand-holding support from very small innovation to become one of the top-class innovators. What I see there is a matter of the kind of the capacity building, kind of the culture of innovation in the country. When I see a lot of students doing PhD research and all, they mostly do research for the want of the job. Anybody going to doing something is not seeing the kind of the point of innovation or creativity. What I feel that if we are trying to provide some protection in the form of model patents to MSME sector or startups, they are going to build up the kind of the hand-holding, and with this small investment, they will start building the confidence and having more investment, and then we can think about the serious kind of innovations. For example, the COVID-19 medicine, can we expect from a very small investor or a kind of the startup or MSME to develop the injection for this particular disease? Very, very difficult, because those who are the big players, they can be finding the medicine, they can be capturing the entire market. So my entire idea is that how in India we can make up the kind of culture for innovation. If we start protecting the small innovation, the kind of the petty patents or low level of the inventions, they will get a lot of confidence, and this particular confidence will be providing them the kind of very strong support to have confidence for the very serious or very quality kind of the innovations and go for the patents. If you see that regarding the people have raised the issue regarding this commercialization and also regarding this number of SMEs. So we have 4.8 million SMEs, and then the kind of patents they are getting is very, very low. So MSME sector is not able to get the high quality patents. And also the startups are very, very low standard kind of the innovations. They are very kind of not able to get the very quality in the invention and the patents. And in the COVID-19 period, 50% startups are already closed. It means that future is very, very dark for them. So I think this can be one of the very motivating factors uniting the entire this MSME sector if we recognize and provide the petty patents in the country. Regarding the economic benefits, I think we are having more benefits than the kind of the loss, because we can debate a lot regarding the enforcement mechanism, regarding the criteria for the granting of the patents, regarding the legal issues if you come up in the system, that we can have serious thinking, and we can really take the kind of the benefit from those countries like Japan, like the China, Germany, those who already kind of they have this particular model, and then we can refine a lot for the country. Regarding the commercialization, we can, I think, start thinking about the use of the blockchain technology and artificial intelligence. Currently, there's a lot of debate happening that can we shift from a centralized model to decentralized model? Can we use the blockchain technology in the entire IPR process? It will help with very fast granting the patent, because now it takes a lot of time to get particular patent. So once we are going to apply this petty patents, it will be further issue that how much time it takes, because time period is very, very short. So what I see that blockchain technology can help the fast process of granting the patents in the main system as well as in the petty patents, and also we can use the artificial intelligence in the patent office for the kind of the granting of patents. Plus the commercialization. Currently, if anybody has a kind of very quality patents, and then he wants to kind of understand that
sir, kindly conclude. You may kindly conclude, sir.
License. By this blockchain technology, it will be very easy to track that who want license. You can find out the licenses, and then you can track who are the infringers. I think with the use of the blockchain technology, artificial intelligence, we can have the very quick disposal of the cases, plus fast granting of the patents, plus you can have good commercialization in the IPR system. So I'm a strong supporter of that. This particular kind of the petty patents will be a great support for the startup business as well as the SME sector. Thank you.
Right. Thank you so much, Dr. Tabrez. I just want to apologize to all the speakers. Like, of course, we, a lot of speakers are there, a lot of issues there. And of course, we understand it's an issue which has been debated since like past 10, 15 years, but still we are not able to conclude. And the discussions which are going on are so much engaging that it is very difficult to stop anyone. Over to the third issue, if Dr. Gopakumar Nair can throw some light on this issue about the scope of protection, the time period, and all.
Thank you, Mr. Sajidji and Dr. Dhumane for this opportunity. I am definitely of the opinion that this is the time to strike. The iron is hot. Government has been discussing on the directive principles, fundamental duties in some of the speeches in the parliament, and Atmanirbhar policy has been announced, and we have left out a large segment of innovators, especially not only from MSME, but from the grassroots of the educational, the students, the teachers and students who are not otherwise enabled to enter the protection of innovations for fear of extreme high cost, extreme high potential for litigation. The cost of litigation is very, very frightful for most of the people who think of going for a registration. So basically, the India is the country of jugaads. We know country of jugaads has been quoted all over the world, including in international forum. So we must kindle, trigger, and encourage all those segments of the people who could join the innovation bandwagon. This is the right time. So I would definitely want to exclude the utility models from litigation. So I would suggest it should be a model very close to the royalty model on FRAND type of terms, and the litigation should be the alternate mode of resolution, and it should be settled, and if it is found to be infringing, it should be subject to nominal royalties, and period should be minimum 5 years, not more than 10 years. This is all what I would like to say. I want to be brief, but I want to see that the students, teachers who are not, the fear of their including in their CV should not deter. This is a very, I don't know, the educational, these things, people, I am of the opinion that should not deter us. We should go for this right now. This is the right time. And I'm grateful to you for opening up this forum for this discussion, and it should be taken to logical conclusion. Thank you.
Yes, thank you so much, Dr. Nair. Now I request Mr. Ashok Shukla to kindly give his brief views on this. I'll just present your PPT, sir. Mr. Shukla, are you there? You're on mute.
Yeah, thank you. Thank you, everybody. In fact, I'm honored by this invitation, and I'm thankful to Dr. Kadam and Dr. Sheetal to send the recommendations, and Dr. Dhumane and everybody else. Now, I'll be very brief. First of all, we were to discuss about the time frame, and I'll come to, even though the slide is not visible, but I come to my slides because there are the basics which I have considered. Something is wrong. There are 2-3 things. First of all, it's the okay, it is visible.
Yes, visible.
Can you please go
Yes,
to
slide.
the next slide? Next. Let me come to the, because all these issues have been already discussed. It's no point discussing things. Next one still. Next one. Next one. Here, yes. As far as the time frame is concerned about the protection of utility models, there are various inputs. One is that in order to be popular, a new modified product or a process takes about 2 to 4 years if it is marketed properly. Then the various toolings and parts of machinery which translate the concept into a tangible product, they have the tool life of 7 to 8 years. And then also this innovation, whatever innovation it is, it has generally a product life cycle of something about 8 to 10 years. So in my view, the time frame should be about 12 years or something. And then I would also like to say that let's not, you can close the slideshow, Sajid. Let's not, now it's not the time for still analyzing whether we should go for this or not, when there are 102 countries which are already having this utility patent or utility model system, of course, in slightly different ways here and there. So I have a feeling that too much of analysis would cause a paralysis. This is time we should go for it, and we should have, as Parmar Saab said, that it's time for certain policy papers, introduction of policy papers. Way back in 2007, Dr. Kardam has done so much work. James Saab has done so much work, and we are still thinking about it. This is surprising. There are so many. I just want to give one example. One of my designs, because I knew that it was not possible to have to apply for some kind of IPR protection in India. I gave it to an Italian company. They paid me the money. The name of the device was a flying cutter, which is used in packaging machinery. They paid me enough money, of course, and then they got the utility model patent for it, and they are reaping the seeds of it. Had it been allowed in India, it would have been a different scene. Similarly, in my group, we have filed 18 patents, and had something like utility model or utility patent could have been there, we would have filed 50 or 55 more by now, because those things we could not file, and those are very valuable ones, let me tell you. Those things we could not file because they would not meet up the criteria of patentability. So I'll close it here. Thank you so much.
Yeah, thank you so much, sir, for your views. We'll now move on to, definitely I do understand, like, speakers are there, they may have the time commitments also, but I expect a bit more corporate cooperation. We'll move on to issue number 4, and we'll start with the views of Mr. Avinash Srivastava.
Good afternoon. Good afternoon, and thank you, Dr. Dhumane and Dr. Sajid, for giving me an opportunity. Am I visible?
Yes, you're audible and visible, sir. Kindly make your comments.
Okay. I will quickly summarize. Basically, I tend to agree with Dr. Kardam, Ms. Ranjana, and Dr. Parmar. You see, look at what has happened in last 15 years in the patent system. In spite of all the efforts, IPRMNS program, this, that, somehow the share of Indian inventors remains at around 30%, 35%. It has not changed in the last 10 years, the share of Indian inventors. So obviously there is some innovation which are being missed by the patent system. So we have to have a IP system, IP system which is designed around the innovation which are happening in the India. So utility model may fill the gap. Okay, but now you see, my topic is what should be the threshold for the examination as far as the novelty is concerned and inventiveness is concerned. Let me tell you what we are trying to protect. Mechanicals, I assume it is only mechanical system and electronic devices and apparatus tools. Software, chemical processes, software, biotechnology, these are excluded. We want quicker grant, not more than 1 year, and protection should be maximum 10 years. In fact, I tend to agree with the 8 years only. And then what exactly is the protection which we are looking for under UM system? Basically, the protection should be against slavish imitation with respect to appearance as well as functionality, because appearance design act is sufficient, but in addition to appearance, there has to be a functionality also. And now the focus is basically, if we are talking about a new utility system, utility model system, then focus is on protecting something which is closer to market. We are not talking about the invention at all. Let us be very clear. We are not talking about the invention at all. Otherwise, you'll be again trapped. So what we are looking at, something, the apparatus, a device which is ready for the market. If it's been filed today, tomorrow it will be introduced in the market. We are looking at those systems. So now what kind of search should be there? And there is another interesting thing. We are complete liberty. We have complete freedom to frame our own laws. There is no obligation under TRIPS agreement or whatever agreement. We are completely free. We can design around an IP system. Now, as far as my opinion is concerned, as far as the search is concerned, search examination for novelty, it has to be on worldwide basis. Search has to be comprehensive, as good as for patent system. But now the next is inventiveness. Let me tell you, there should not be any search on inventiveness. let us completely break from the patent system. Otherwise, it will be self-defeating, because if we go for the inventive search comprehensive examination for inventiveness, then it will be costly, it will consume time, and then we are again inching towards the patent system. Because let me tell you, how do we say that lower inventive criteria for utility patent and higher inventive criteria for patent system? On a scale of 0 to 10, if we say 0 to 5, then you should be protected in a utility model, and then 6 to 10 under a patent system. How can we decide? So we are again in a trap. Let us not follow the German law. Let us not follow the Chinese law, that there should be some interoperability kind of thing between a patent system and utility model system. If we at all thinking for utility model system, in my opinion, let us take a complete break from the patent system. It has to be a sui generis kind of system, as Mr. James has pointed out, with its own, with the system designed around our need. So if we can do that, then it is going to help. Because somehow I have a feeling, I have been in this area since the last 20 years, in spite of all the efforts, the patent system is unable to capture the activity, the innovation activity, at least in the area of manufacturing. That's all I want to say. Thank you.
Yes, thank you so much, Mr. Avinash. Since positive time is there, we'll be taking up views from the speakers who have not spoken. Dr. Malati, are you there, ma'am? Hello?
Yes, I'm there.
Yes, ma'am. Ma'am, kindly give your views on these issues.
Yes, I'm just going to take, I think most of the speakers have done a good job and they have spoken most of the points here. But my topic was, how do we do this? A sui generis law is preferred for the utility model in India. What I feel is that, is it under the Designs Act? I don't think it is suitable for inclusion of this in the utility model in the Designs Act. The reason is the basis of the Design Act is opposite of the utility model. Design Act is premised on the appeal to the eye, the aesthetics, and not on the functionality which we have in the utility model. So we will need another law, another act to take care of this. It cannot come in the Designs Act, it cannot come in the Patents Act, because we've seen that the threshold of patentability is pretty high in the Patents Act, and we do not allow improvement patents or improvements or innovations under Section 3D, Section 3, and if you look at all the Section 3, we may not be able to get. The other thing that you see is a lot is software-based or pharma-based or biotech-based, and all these can't be done under the patent law nor under the utility model. What I want really the government of India or all awareness people is, have we improved the number of design filings in this country? Once we come to a high threshold of design filing, which doesn't need to have a functionality, then the question then comes is, can we go? So if you look at the Italian model or the German model or the Japanese, it was all based for manufacturing. What are the different types of designs or structure or shape that we can actually capture? Are we there now? My first thing is just increase the number of design patents from India without capturing for the functionality, and then comes the next. So I think we need to really look at this. If we have a utility model, we need to have a separate act. It could be a sui generis act. The novelty stringency has to be lower than that in the patents. The inventive step also has to be much stringent, and we must have inventive step with a lower standard. It could be for 3D devices. We still need this first to file and allow a grace period. We could use the utility model for the startups. They file it first, and then they can go and apply for this patent as well. So that's all. I don't want to take too much time because I know there are many speakers and many of the topics have already been covered. Thank you, Sajid.
Yes, thank you so much, ma'am, for your views. Definitely. Now we can we have Yogesh, sir, if you're there?
Thanks, Sajid. Yeah, yeah.
Of course, you have written earlier also on this issue.
So,
we have the whole discussion paper. We have read it. Would
yeah.
you give your views, sir?
So I decided to speak on enforcement. See, one of the critical problems that currently faces the patent system is the notice function. And because of the notice function, there is a certain amount of clarity with reference to the boundaries of the patent system. And that plays out in litigation in a big way, because in India, we have a system of grant of what you call ex partes and quia timate injunctions, and also, interim injunctions. And that completely stifles, the defendants who are usually in a position to challenge the patents, and sometimes the validity of the patents are being challenged. Now, do you want to have a simple similar system with reference to utility models is a big question, because if you go that way, then the existing problems that you see with the patent system will come up in a big way into the proposed utility models regime, if you want to call it. So I for one would like to see that even if you create a system, because I am keeping a very open mind on it, we should have what is called as a liability rule system, wherein there must be a way out, not to see that it functions as a property-like system where anybody is allowed to exclude, but there is a system of compensation that flows back to that extent, because the risk-reward ratio in case of utility models is very different from the risk-reward ratio that you expect for standard patent for inventions. The risk that is taken in case of utility models by smaller SMEs is very different kind of risk when compared to big tech like Ericsson or IBM or other companies that do. So I think that's where we need to focus on. Even if you create a system, what kind of enforcement regime you create, and that enforcement regime definitely should not be based on the property kind of system wherein exclusion is the way in which it functions. It should be based on a compensatory system wherein a certain amount of compensation should flow back to the person who is the owner of the utility models by the person who is the alleged infringer. Because if you create a system, then there is going to be fair amount of litigation, and that's going to create some problems. With that, I'll stop here. Thank you.
Thank you so much for your views, sir. Now, can we have the views of Dr. Miss Anuradha Maheshwari, ma'am, if you are there?
Hi, can you see me?
Yes, ma'am, we can see you, we can hear you.
Good evening, and thanks once again, Dr. Dhumane, Honorable Registrar, and Dr. Uke for giving me this opportunity, not the least, of course, Professor Sajid. It's been a pleasure to be part of this roundtable, but I sort of I see myself actually, after hearing everyone, to be in the minority where I am an active proponent of the utility model, and I'm going to unabashedly present my views for them. I work a lot with startups and SMEs, and I see the kind of trouble that they go through. So for this, I would like to briefly, while I understand the kind of issues that are there in what we call as, creating the kind of regime for utility models, I hope this slide is visible to all of you. I've just done two slides. One is on the overview of the kind of SMEs that we have. Is it visible?
No, ma'am, it's not visible.
I just wanted to show that, the SMEs today, this 34 million SMEs that we have, 95.5% of those SMEs are micro industries. And they are contributing, all of the SMEs together are contributing to 45% of India's manufacturing output. Of those SMEs, 31% of them are in the manufacturing sector. And it is in this manufacturing sector, apart from the other sectors, that we see a whole lot of incremental innovations. Those innovations which are happening on the workshop floors, those innovations where there is not a heavy R&D kind of investment, but people are using their intellect to create some interesting, innovations that we can see. Also, one big problem for the SMEs and the startups is that they are not having the financial, the economic, and the mental bandwidth to go the entire route of patenting as we have today in India. So it's very important for us to encourage a culture of innovation, also integrity amongst the SMEs who are always, trying to copy one another out, and create a system where they are encouraged to protect their inventions, call it innovations, whatever we choose to call it. So given this background, I sort of looked at 5 models that we have of the utility models that are there in the country. I've heard a few of the speakers over here giving, mentioning that there is no empirical evidence and, we'll have more litigations. As a lawyer, I would just like to say that there are laws that have been created against theft and murder, but none of them have stopped. So should we scrap those laws? Likewise, we have a great law for patenting, but look at the paltry amount of patents that we are filing as a country. On the flip side, we need to know that there are 100 plus countries in the world out of the 192 countries who have adopted a utility model system and which is working fine. Nowhere can we say that it has failed. So when we are looking at Southeast Asian countries with whom we share a compatibility in terms of population issues, the kind of, demographics, so they are models for us to emulate. Not last, but the least, as I would always say, is look at countries like Japan and Germany who have utility model systems for over 100 years old and which are working fine. So my issue today was to say what kind of regime we should bring in terms of a sui generis regime. My first thing, and I know that many of you would disagree, my thing is that we should keep it only for the SME sector in India. So we, like the Patent Act has a kind of a segregation category of startups and individuals, then we have SMEs, and then we have others. So let's create a model which is only for SMEs and startups and individuals so that the others are clearly out of this model. This for India. Even those who are filing from abroad will have to fit into our category that we make while filing in India. Coming to conversion, many of the countries have kept conversion open because this is allowed by Paris Convention, not mandated by TRIPS. So the enabling provisions are there in Paris Convention, and so we find that countries have allowed the system where somebody who files an utility model can file a patent, or somebody who has filed EU patent or EP patent has come back to the country to file a utility as well as a standard patent. I differ. I feel that we should bring in the kind of Chinese model that is there. China, very interestingly, allows a dual patent, which is on the same day you have to file both the patents, the utility as well as the standard patent. However, only one will survive. So once your patent is granted, you will have to decide whether to keep the utility patent on or to keep the actual patent on, the invention patent on, which is a model that we also could adopt in our country, where we say that, we will give the option of converting, but it should not be for the same invention. It should be for a different invention out of that same thing. So where patents are rejected, where patents are opposed, recommendations should come from the patent office that please file a utility patent. So we can create various means in our system for filing the utility patents, and I think we can work towards that goal. I agree with Mr. Pai when he says what he says about enforcement, because that was the topic also that we were supposed to speak. So enforcement is something that should go parallelly as with the Patent Act, and we could adopt systems where we look at, how much profit has the infringer made, what are the losses that the innovator has made, and based on that we could come up with a system where there is more arbitration rather than litigation. So these are some of the things that we have to, when we come out with the paper, lots of inputs can be given as to how a model could be designed for utility patents. I also want to add on, I always believe that now is the right time. Whatever has happened has happened. It has not come out for various reasons, but let's look at creating a more enabling environment for the SMEs in our country so that they can work towards a brighter future. If we are looking at Atmanirbhar, then I think this is one step forward for creating that kind of system and the culture that we are looking at. So again, I repeat, the utility model should be just made available for SMEs and not for any other segment so that it remains protected in that group. Thank you so much. I'll wind up over here.
Yes, thank you so much, ma'am, for your insightful views. Definitely, now is the time to have this once for all. Dr. Gargi, are you there, ma'am?
Yes, I'm here.
Yes, ma'am. Over to you, ma'am, for your views.
Yeah, very quickly, I just jotted down some point. I mean, see, every possible thing is having the pros and cons. Okay, so I'm just talking about the two prongs, this particular thing. So first, we need to think about the what type of. I mean, most of the country like Japan, German, they are protecting the product, not the process, not the chemicals, not the medicine, not the softwares. So we need to figure out that what actually we want to cover under the utility model. That is the one thing. And of course, the cons are, I mean, as per our socio-economic condition, we know that we are into the public domain. So SMEs or Jugaad innovations, how much Jugaad innovation we are actually commercializing it? That is the question. Now, the thing is like that. Another layer of IP. So can we shrink it? I mean, are we shrinking the public domain? That is the one particular question. So they're ready for it. Or it is really theoretically, we know the jurisprudence of IP that it is giving incentive, investment can come, but is it only the theory? So I can remember Jogesh started that work based on that, the very last minute, some work I have done on the same paper, Jogesh mentioned that. So it's 2013-14. So at that time also, we propose that there is a need of a extensive empirical research with each and every industry, that as per their economic condition, as per their socio-economy and socio-cultural condition, because sharing is much more in the SMEs in India. भाई तू क्या कर रहा है, मुझे दे दे, मैं देख लूं. So there is no licensing, there is nothing like that. They are happily doing business together. This is the typical environment of India. So how much we are ready with that? That is the one question. So with all these things, but I just want to mention, I have mentioned at that time also, I am somehow in favor of unregistered design. Just for the look, not for the functionality where look can be. Now, India is too much into service industry rather than manufacturing industry. We know the matter of fact. So the retail, the GUI, all these things, the look thing, we can cover under. Now, what is the prospect of the unregistered design? That is, it is automatical. Now, I just need to keep that I have published it. There is some documentation, advertisement or something, I can intimate that from that day of publication, I'm getting the automatic protection for the unregistered design. It for the 3 years. Some country it is higher range. We can have our own way. It can be 3, it can be 5. How much India is needed? That can be one good way out. Just based on the look, not the functionality. Good lot of things we can cover under the unregistered design. That is one thing. We need to revisit our design law, and we can think in this line also. That is the one thing. Just last one thing I just want to tell. I somehow like it. So India can think about it. Germany is having this splitting of understanding from patent law to UM or utility patent to come out. So what happened when any patent is pending? Examination is going on some way, some tug of war is going on. So from a filing date, so what is the prospect of the splitting off? I can reserve the priority date. So my novelty is not going to be lost when I'm converting the patent application to the utility model. And 10 years, even after 10 years of filing, I can split off from patent to the utility model. That is there. Now, in case if there is a withdrawal or rejection or something, opposition, something happened, within 2 months' time, they again can go to the utility patent from the actual, the conventional patent filing. So this splitting of understanding is, if we are encouraging or we are into the utility model, that is the debate is going on. And if you are taking in a positive note, yes, we are going for the utility model, then I think the splitting of idea is a great idea to just shift from one to the another, that where the patent stuck, but the lenient way I can enter into the utility model. And of course, the duration also needed to be fixed on that. That's my call. Thanks. Thanks for calling
thank
me.
you.
Thanks, Dumanesa. Thanks, Sajid.
Thank you so much for your valuable views. Definitely, this switching option should be available. And definitely now we'll have views from Dr. Pranjal Fukan. Yeah, sir, you're on mute.
Good evening, everyone. It is really a nice program which I'm just hearing for since 3 p.m. And it's really very nice. I'm an industrial person and I'm actually totally professional in industries. With my focus is on procurement and contracts and sourcing and all. And I'm handling a lot of MSMEs and startups. And what I found that there may be some complex issues in when we speak of the legal part of the situations, which I am not much aware of. But on behalf of what others are speaking on this, the most important thing, if you see the focus of the government on self-reliant India, or if you see so much of policies are coming up, so much of things are happening to make these people stand up, so that we can have tiny micro sectors get viable business, sustainable business. But unfortunately, we cannot protect their ideas and innovations because we are not having such systems in place. And whichever is happening, whichever is available in the space is basically very complex, very cost effective, it requires cost, it requires money, which big players are taking advantage of this. So I think this utility model, if should be, in my opinion, should be implemented in India, maybe as a trial basis, maybe on the trial basis I was saying, because I am also a science student, so I know can be put on trial basis for some time, like Australia has already scrapped this utility model now. So we can also make a trial basis with with lesser paperwork, with lesser investigations activities, lesser cost for lesser duration of time. Maybe for I think maybe for 3 years it can be allowed to check and for having a check and balance in the whole economic complexity system of our country. At least we can motivate these people to think something, to have innovations. We are speaking so much of like innovative decision design thinking, all these incubation centers, but nothing is coming out because the ultimate goal is that if they are thinking also now where to park their thoughts, where to get their legal rights on their thoughts, on their ideas. So very practically speaking, keeping apart the law and regulations part, government should try, we should try once at least for to how it works in Indian scenario if implemented, with some modulation, modifications for trial basis. If not working well, obviously our constitution is getting amended every time, so we can also have the option to get it amended. And fortunately, utility model part is not under the TRIPS scheme, so it is optional to the country to country. So we can have a look into this, which is my opinion, and I also request the authorities to at least have a look and at least implement for once, so that we can see what are the things which will crop up in due course of time. Thank you very much for giving me this opportunity, Sajid. Thank you very much.
Yeah, thank you so much for your quick comments. Yeah, so now of course in some manner we have covered like all the issues today. I am really thankful to all the speakers who adjusted with the time, and the engagement was so rich on each of the issue that we somehow lost the track of time. But definitely before we go on to our chief guest for the concluding remarks, let us have like quick comments and quick reactions on the discussions which have happened today, which started from the whole IP perspective from various countries to the need of having this very law right now in India, and making this IP system inclusive, including not only big players but also small players, mediocre players, and especially the micro, small, and medium sector enterprises. So just to have quick view, I'll request Dr. Tabrez to give certain remarks.
I think if you see the debate, mostly people are in favor of of the model patents. because we are saying India for Atmanirbhar Bharat, also vocal for local and all, to really make it workable and also really to make a culture and tradition in the country for innovation creativity. I think we start protecting the kind of small innovations and small kind of the value additions in kind of the mechanical instruments and all. This will be giving a lot of confidence, trust building, and also people will not be fearful to have the investments. And this way we have a lot of kind of culture in the country for innovations and the confidence building, and then the starters business and some SME will be getting confidence, they can grow. So I am in strong opinion that this is the right time to really go for this kind of model, and we definitely do a lot of research to see what can be the best law for the country, keeping in mind our socio-economic condition. Thank you.
Thank you so much for your views. Ranjana ma'am, do you have some final comments on this? You're on mute.
As I said earlier, I think the kind of situation we are in India and the kind of MSME movement is going on and the startup, I strongly recommend that this is high time we should think of, accepting the fact that yes, we need utility model provisions in India. Modalities, I still believe that yes, it would require much more deliberations and debate. I mean, it's not easy that, we come up with that 5-year term or 10-year term. Yes, there are legislation. We can learn from them, from the foreign jurisdictions. But yes, I believe that we need to seriously consider having utility patent.
Thank you so much, ma'am, for your positive views. Professor Irene, do you have some comments on this? If you can unmute yourself. You're on mute, ma'am. After Irene, ma'am, we'll go to Mr. Shukla.
Was fascinating, and I am again very honored to have been involved in this discussion. I think a lot of good points have been raised by those who support this right, and by those who are, maybe I am among this second group, a bit more skeptical. But I think we all agree that we want to see how IP can actually promote innovation for not just the big players, but also the smaller player. I was very interested by Madam Mashevari's statistics about manufacturing and the number of them, even if it's just 31% of a smaller Indian Zaids sector of this SMEs economy, it's still billions in terms of potential revenues. And the real question again is quality. Are these not becoming a rubber stamp that then can clog the system even more and trigger litigation and become a weapon in the hands of somebody to say to somebody else, you can't do that because I have a right, so you have to license it from me. And by the time we want to invalidate this right, it's more expensive than actually a license. But again, the system could actually create obstacles to avoid, avoiding frivolous filing and so on. So the system, now that we see whether India wants to go with the system or not, perhaps needs to be based a bit more on more research. But regardless, if India decides to go, India has a lot of good examples from abroad of what didn't work too well, so it can create a system where some of the same problem could not be repeated. And I think that could actually be very important. And that's fascinating.
Thank you.
Yeah,
thank you so much,
really
Professor.
Reminds back to Miss Ananda. Is the current design system not really equipped enough to be a surrogate of this utility model system, like the European design pattern actually is because in Europe we don't have a European utility model. We have a European design. And the non-registered design as well. That's really useful, the non-registered design for the very small SMEs who might not even know having something valuable until they start to commercializing it. But thank you again. This was fascinating and very well prepared. So congratulations again.
Thank you, ma'am. Very nice to hear your views from a no-no to a bit of a neutral, that we may have this model with a bit research. Anuradha, ma'am, you wanted to make a quick comment on, I think, design part.
Thank you, Irene, for the fact, the kind of things that you said about my presentation. Basically, just wanted to highlight two issues over here. We do have a very robust industrial designs law, but that is protecting only the aesthetic appearance, the external appearance of articles of manufacture. And that does not protect the functional aspects. So in my mind, an utility model system sits bang in between the patent systems and the design system. That's where it fits in. Coming to the second point that you've been raising about quality patents, that is exactly the objective of utility models, where we are not looking to extremely quality kind of patents like in an invention patent, but we are trying to protect incremental innovations which do not fit the bill of the inventive step. So the threshold of inventiveness is very low here. And what we are going to, I would recommend India follow an examination system. There are utility model countries where examination is allowed, but we can have prima facie examinations like the design model, where it is only to the eye, it should be just above the prior art, and it should be granted a utility model. I also would like to respond to Dr. Gargi. The conversion that she talked about, splitting off or branching off in the German system, see, that is exactly where the problem lies. The German system is being manipulated by large players, and they seek both the utility patent as well as the invention patent. So when they are facing a problem in prosecution, they can still manage to protect their invention through the utility patent. My view is that we should not have this conversion system. We should allow utility patent only when the patent is rejected. So in that sense, this model works far more fairly for the SMEs rather than being manipulated by large players. So
thank you so much for your quick views. Mr. Shukla, your concluding remarks.
Thank you. First of all, I'm really thankful to Dr. Dhumane and Sajid, you, and for all the people. Secondly, let me answer Dr. Irene. Dr. Irene, it was one of the Italian companies which actually bought my design because I was not able to file an API protection system here, and they filed the application in Germany, and they got it, and they are minting money on it, and all I got was $3,000. That's all. Secondly, this was a very good session. I just want you all to have, because as I said, too much of analysis causes paralysis. The meaning of the word law per se is perceived by the common man as something which manipulates the wordings in such a way that an act not justified in a normal way is proved to be justified. So while in most of the cases it doesn't matter because the law doesn't come into picture, but IPR, it matters a lot because the legal fraternity should not intimidate the creators, and I'm afraid that is what is happening all over the world, and more so in India. So we got to be careful. I am from industry. I am an SME, and earlier I was managing 6 companies. Now I have bought 3 companies from the chairman, and I'm managing them as my own. Many of the patents from SME, we don't really need for filing patents. Also, for developing technologies, we don't really need so much money as people generally think. 18 patents with a very, very small investment. It's this which really matters, and the hard work which really matters. And behind that 18, there were perhaps more than 50 of them which we could not file because we don't have a system. So we need to go ahead. That's it. Thank you all.
Yeah, thank you so much for your views. Mr. Yogesh, are you there? Would you like to make some last comments?
No, I think, this was nicely organized, except the, time we took in concluding it. I think it was all fine. The views were expressly, very clear and very welcome. Thank you, Sajid, and thank you, Dr. Dumani. Thank you, MNLU, for inviting me.
Thank you so much. We can have a quick comment from Mr. Avinash Kumar, if you would like to make comments. Sir, you're on mute, sir. Could you unmute yourself?
Yeah. You see, nobody said that we should not go for utility model clearly. Okay, what they said that if at all we are going for utility model, a lot of research is required, and maybe some inputs from the SME sector also. But again, if we are going for utility model system, my view is that it has to be separate from patent system. Otherwise, if you start talking about examination from the inventiveness, all kind of problem will happen. Okay, that's what my final view is.
Thank you.
Anyway, thank you for inviting me. And it was a wonderful session. Wonderful
yeah.
session.
Professor Padmavati, can we have your views?
Great views, as I, very nice to be on this session. And as I had mentioned in the beginning, we need to really relook at this entire concept of utility model. I would believe that it's the right time to look at it. In 1891, Germany had introduced it. There was a reason. The IP system has been really very accommodative. And today, as we see, there's a greater focus on development dimension, and that provides the right justification, I believe, for utility models, where the industry and the focus should not. It's not just about small industry or big industry. At least it provides an opportunity. And with India now going into Make in India, where it is indigenous development, develop, produce, and also commercialize. I think this will give a good impetus to that focus as well. If you look at Atmanirbhar that they're talking about, that also again can be focused. We'll see some outcome. You see, the very fact of the IP system was to reward, and we should not shy away from looking at a utility model protection. Well, there is an aspect of making the law. All that comes in at a later point. But if you look at all the studies that have been done, Kardam has worked on it, James has worked on, many others have really deliberated and researched on this. There are certain economic, studies also done. Given all that, I think at least one thing that comes to my mind, if you see US as a country has experimented well with the patent system. They have introduced 10,000 is the number we will look at for a cancer genome project or cancer pilot project or a space pilot project. And later on they phased it out once they found that they could capture all the IP. Why not a utility model protection for a limited period of time? Let's experiment with that and see that how many are being filed. And maybe you can have something like a 10,000 target time or a 5-year target time, and then phase it out. US has done that at least for 3 different specialized programs under the patent law.
Right.
Today energy inventions, you talk about space inventions, cancer pilot program, they've successfully run that. They've also had limited examination practice on certain special examination routes as well, where they've phased it out after a given point of time. So, I mean, I would believe that it's the time really to relook at and go for some level of protection. Separate protection, yes.
Yes, thank you so much for your views, ma'am. We'll have views from Mr. Parmar and then last views by Dr. Kardam. Yeah, over to Mr. Parmar. Your concluding remarks. Your mic is on mute, sir.
I'll do that. Yeah, I could see as I said, the old timers and the young bloods, both are of the same opinion that there is something called utility model. When I called it as a differently enabled invention, most of the people agreed to it. So we have to look at it from that point of view, calling it as a utility model or whatever way you want to. We must have a room for all inventions which are useful for the humanity. We should not call them non-inventions rather. We should call them inventions if they are useful for the humanity, or it is useful for the upgradation of quality or utility appearance or whatever ways for the domestic purpose home products or in the industry. Some inventions which are stopgap arrangements. They are filling the gap for the technology. they should have some space in the IP system, and that some space should be provided by the should be provided for the differently enabled inventions, and they deserve it. They do deserve it. They should not be left as orphans at the hands of the pirates. So they should be given some protection, because these are easy to copy inventions, and they should be given some more protection rather than less protection. That's my view on it. Okay.
Yeah, thank you, Mr. Parmar, for such positive views on this. Dr. Gargi, are you there? Would you like to give your last views? Then maybe we can have final views by Dr. Kardam.
Yeah, I mean, thank you for calling. Thank you so much. What I'm trying to say, Kadam, mentioned about Dumane sir, why I have mentioned about the unregistered design. Sir, I'm not telling that unregistered design and utility model can go simultaneously, because one is covering the functionality, one is not covering the functionality. What I'm trying to say, in itself, our design act needs to be revisited. If the utility model is going to be introduced, as per Padmavati ma'am, short-term basis, as per our need to play with the IP like US or EU, because they actually, with their flexibility for a long time, they settle down their patent. What we didn't get a chance, because we have started quite late. So they got the time to play with the patent system, and as per their way, as per their industrial development, they now in a position. What we didn't, we have started very recently. That is the one thing. Now the thing is like that, if we are introducing obviously, if we are not even introducing then also we need to revisit our Design Act once, because I think Design Act or design law is simultaneously having a huge potentiality. So sometime as a model, one product as just for a model and look wise, also under Design Act, we can give certain protection. Though I'm not covering the innovation or technology behind it, but as a look, I can give one protection that I tried to say, sir. It could be a one way that I tried to mention.
Right. Thank you so much, ma'am, for your views. Over to Dr. Kardam for your final comments, sir. Your mic is on mute. Could you unmute yourself, sir?
Thank you, Dr. Sajid. And I once again thank MNLU and Dr. Dumani and Sajid for inviting me here for this important discussion. In fact, you look at the utility model objective globally. The two things are very clear, very clear message given to the people, that it encourages the innovation of the domestic people. So if you look at statics, it always you find that it I think 85 to 90% applications filed by the domestic innovators. So it encourages domestic. Out of domestic, I think it is mostly MSME people are benefited out of this kind of system if you look at globally. Then IP policy also focusing, India's IP policy focusing to increase IP application. So under the Patent Act, we are not moving. Every year, I don't think any 5% to 10% increase is there in the IP application. So I think still not we are able to achieve those 10% figure in patent filing. Especially the domestic filing is also quite low compared to foreign. In most of the country, it is otherwise. The domestic are more and foreign are less. But India, it is domestic are less. 30% now, it is 35, but still 65% application filed by foreigners. Thirdly, that's what one has to look at it. Now, if you look at the Indian innovation inventions or patent application filed mostly from the cities, nobody is bothering about the urban areas. Mr. Shah was talking about the NIF recorded 2 lakhs innovations were out of how many, only few were commercialized. Why? Because those applications could never see the protection, could never see the protection. And why? Because the patent, under the Patent Act, the requirement of patentability are quite different than utility model. But overall, if you look at it, I think utility model is good, although we are quite late. When I did the research in 2007, I think 13 years are already over. But considering the new initiative by the government, like everyone talking about the Atmanirbhar Bharat and all these kind of things, I think we can revisit. But especially before we do that, I think there's a need to do further research in the sense that especially the MSME sector, individual people, how many, patent applications are filed, and why there may be people like NIF, National Innovation Foundation, why they could not protect those truthless innovations under the Patent Act. What is the reason? What are the reasons why they could not do it? Although, some people are, individual inventors, their applications are rejected. I think we can understand the pain of those people whose applications are rejected for lack of novelty and inventiveness. So maybe when we approach those kind of people, they will really let you know why utility model is required. Because I think these are two points, I think, that that requires the revisit of utility model. Although we are late, but
better late than never. Better late than never, sir.
Never. Yeah.
Thank you so much for your view, sir. Now, of course, our honorable chief guest, I must thank him because though we asked only 2 hours of his commitment, but of course, it's more than that. Now, over to you, sir, for your concluding thoughts on this entire discussion, sir.
Thank you, Sajid, and once again, my congratulations to both of you and others also there. Now, what we found was that most of the participants were in favor of a utility model protection, and that too in a sui generis manner. I'm so happy that those who are from the industry, the real industry, the MSME sector, and those who are working with them, they were vociferously supporting it. And Mr. Ashok Shukla gave figures also what was happening to the industry with this thing. And Anuradha, of course, very vehemently supported this proposal, and she is, I would say, the activist in this thing. Congratulations to her. And
thank you. Thank you so
much. The very few who had some reservations, they were saying that, what about the economic impact? Have you done an empirical study on the economic impact? Did we do any such study before introducing any IPR in this country? And if we had done an economic impact study, perhaps many of them would not have been there. That's one. The second aspect which they put, this reminded me of an anecdote which Dominic Lapierre mentioned in his 1000 Suns. He is the author of Freedom at Midnight. He was coming to India for researching on freedom at midnight. He wanted to buy a new car. When he went to the Rolls-Royce showroom, they refused to sell him a car when he said he is taking it to India. That was the economic impact. He, of course, purchased a second-hand Rolls-Royce, brought it to Delhi, and there was some trouble, and there was a mechanic, British auto works. They repaired it, and more beautifully than any Rolls-Royce fellow would have done. So that was, it is a question of impression and not the real facts. That's one. The second aspect is they are mentioning what a burden on the IP infrastructure. Yes, there is burden, but then that depends on what kind of law you are making. And does it mean that we should not be there? Then there was a mention about won't we have more human resources? Will we have more officers or separate office? The third thing is they mention about the judicial system. Now, if you look into the IP cases, if my colleagues are there, they can support me. 90% of the IP cases relate to trademarks, not to patents, and around 6-7% to copyright and a few to patents. Does it make anything? So this is all normal facts of this thing and nothing about it. And the last point which I want to say is there can be different kinds of IP and different kinds of protection. In fact, if you look into, nobody here mentioned about the new education policy. There was reference to impact on education. What does the new education policy say? Let people move out at any time and get into the professional or working area or industries and all those things. So this is some system which enables you to cut at this thing. It doesn't that just because we have IITs, it doesn't say that we should not have ITIs. Will we work for such a thing? No. We should have only IITs. No IITs. It will kill the innovativeness. Does it mean? So let us admit, all sudden that is unity in variety and all those kinds of things. But so it is there. Different levels of ITs are there. Already you can see basic thing is revelation, but trade secret is not to be revealed. No contradiction. Then new, original, all these things are there, but nothing so about geographical indication. They have to be old. They have to be there already. It should not be new. So the IP system itself, they adapt to different business. So far, they were adapting to the Western world. Why not we look into our country? Mention about 102 countries having. That's not what moves me. What is suitable for our country, our economic and social impact? Any study, I welcome Yogesh's listening. Let us go for study, but it's not mere economic impact. The social impact. How much of the motivation those small inventors, when they get a recognition, then they get a small certificate from a local minister or even a panchayat president. They are so this thing about it. That thing you have to look into. Because why I am saying this is, I had traveled in the rural areas, particularly around among the MSMEs, and they were, the small things, that's what they are looking for. They are not asking for so much money. Money is something, yes, it can come. We will definitely provide them, but that kind of motivation, that kind of reward, that's what they are looking for, that satisfaction. So I would say that let's go for these things. Let us discuss in more detail what kind of a law it should be and how it should be. These are to be done very carefully and all that. That's all. Thank you very much for organizing this excellent roundtable. It was really good roundtable. It was not a conference or a seminar. So I'm so happy about it. Thank you very much. Thank you all, and congratulations to all.
Roundtable without table. Thank you.
We are still on our table. That's important. Congratulations. Good work, Sajid.
Thank you.
Thank you so much, everyone.
Thank you very much.
Thank you for coming and giving your views. Pardon me 1 second. Let me remind you that I'll send one email once again. We of course need your written comments also, because we want to develop this very deliberation what has happened further also. It should reach to a conclusive end also. So thank you so much for all your support, and really I apologize for this lack of time management, but of course having so much eminent experts and limiting them to time, it's a task which is totally impossible. So on behalf of MNLU Mumbai, I respectfully thank everyone, to our Honorable Vice Chancellor for his support, to our Registrar Sir who was here for the whole 3 sessions, though it is not his domain, but still he wanted to be with us in this, and of course Dr. Dhumane for conceptualizing this very idea and for helping and converging all these IP experts, all these very leading minds. Definitely with better time management, we'll have more such discussions, and I thank you all once again. Thank you, everyone.
Thank you. Dr. Dhumane.
Bye.
Thank you very much, sir, all of you.
Bye, Sajid and Dr. Dhumane, and everybody else. My God, the entire IP fraternity